EERC. And before we start, we would like to take a safety briefing from the managers of this facility. Please come forward. Can somebody help? There's a microphone there. Use the microphone and tell us whether we're safe or we're not safe, whether we should go and get our security and everything.
Good morning, everybody. My name is Daniel Kassemobi, the person in charge of the cleaning in the facility. Yeah, it's an honor to be the one that is chosen by the facility to address on the safety. First, when we talk about safety, we should be looking at some certain measures. Let me just be brief and talk about the muster points. We have 4 muster points in the facility. We have one very close to the amusement park, the other one at the front of the ICC, and the other one is close to the Priceless, and we have another directly behind the building. The toilets located, we have 44 toilets in the premises. All are well cleaned, has their cleaners in them, and the environment is safe to be used. Thank you, sir.
Thank you, thank you. So once again, we say you're welcome. This is a special day. In the Mercy, it's common to have bickerings here and there, but this is the first time that the regulator and the licensee are going to be reviewing tariffs in a public forum. And I think it's a welcome development. We are all taking front seats in the arena of history with this development. We also want to thank MAINPOWER that decided to use the provisions of business rules to ask for a review of the tariff order that was issued. It is like in every relationship, misunderstandings must happen. But when they do happen, it is in the interest of everybody that they get resolved. So it is not unheard of that the license So it's not unheard of for the licensee and the regulator to have a forum like this. The is fully covered by the provisions of the Commission's business rules. The business rules were adopted in 2024 after consultation, and they provide for how occasions like this should be treated. And so our guidebook the business rules, we have a copy here, and we trust that all the parties have a copy of the business rules. And we are going to, it's only necessary that we have some introductions. On the panel here, we have a panel of 3 from the Commission. I will ask my colleagues to please introduce themselves.
Good morning, everyone, and welcome to this historic event. My name is Dr. Chuka Akunle, Commissioner, EERC. Thank you.
I'm the Chinedu Commissioner for Engineering and Safety.
Okay, my name is Ruben Okuyu. I'm the Commissioner for Market Operations, EERC, and I am chairing this panel with the help of my colleagues. So the panel is supported by a secretariat, and the secretariat is seated. The secretariat is headed by the Commission Secretary and General Counsel by me, Chidinma. Please, can you stand up for recognition? Thank you. And the Commission is also supported and assisted by the Commission's consultant regulatory expert in the person of Dr. Marilyn Amedi. Please, can you step forward and be recognized? Thank you. The Commission is also supported by the official recorder. The official recorder is Barrister Chinelu Ozude. Please stand up for recognition. Thank you very much. Thank you very much. Now we have approved intravenous organizations, groups that formally applied to be recognized as people of significant interest in the subject matter. And they were recognized. We have 5 different organizations that applied. We have the Manufacturers Association of Nigeria. I don't know whether they are here. Manufacturers Association of Nigeria. Okay, maybe they're still on their way. Then we have the Enugu State Electrification Agency, ESEA. Are they here? Right, so we have the SICA. SICA is the short form for Southeast Electricity Consumers Association. Are they here? Can you see stand? Yes. Thank you. Thank you. You're welcome. So we also have another group by the name of NICA. I think this is short form for Nigeria Inclusive. Can you help me? Please, can you see me stand? You're group. You're welcome. And also, Enugu Electricity Distribution PLC, EEDC for short, is also recognized as an intervenor. Please, can you see the representatives of EEDC? You're welcome, sir. Thank you. We also have an observer status reserved for the Enugu State Multi-Door Courthouse. I don't know whether they are here present. If they are here today, okay. I think we should. Yes. Thank you. Thank you very much. Yes. So the esteemed stakeholders, all of us are stakeholders, by the way. Even you are an operator, you also use electricity, so all of us are stakeholders. So all of us stakeholders, we are welcome. I know it meant a lot for you to leave all the business of the day to be present here. We hope that a few more people will be here. And then we understand that we have online participants, and we say you are welcome also. So we have welcomed the general public, members of the press that are here. We also welcome, and we want to share with us some rules or some housekeeping that we want to observe in this proceeding. So the first I'd like to inform us is that this proceeding is in the form of quasi-judicial inquiry. It's not a court, but it has some similarities with a court. And because of that, we observe certain forms of conduct. In this place, people will not clap. Maybe you want to hear something that pleases you. And in this place, people will not heckle anybody who says something that you don't like. And we ask that your phones, please put them on the mute. We understand Nigerians' attachment to their phones, even when they are in the aircraft and they are told to switch off. They find it difficult, but this occasion, we're not asking you to switch off your phone, we're only asking you to mute them so that you don't interfere and interrupt with this proceeding. Now, because of its nature as a quasi-judicial proceeding, people who will be presenting their depositions will be sworn. They will be taken on oath by the Commission Secretary, and they swear to tell the truth, the whole truth, and nothing but the truth, and with the consequences that we rely on it, criminal sanctions that will follow. So that is that. And the order of presentation will start with the petition, which is MAINPOWER. And when MAINPOWER comes up, that is our witness stand, the presenter will take the witness stand and will be sworn and will adopt the position. Because you are the petitioner, we give you 10 minutes to adopt that and summarize what you have in that petition. After that, interveners who are present can ask them questions, cross-examine them, interrogate their submission, and we will have a maximum of 2 questions to ask. So if you are going to ask a question, please think carefully so that you make sure you hit the target with the question. You don't have all the day to do this proceeding. So your 2 questions, make sure that you hit the target when you ask the question. And then after you have interrogated the submission from the petitioner, in this case MAINPOWER, then the interveners who have submitted the positions will be asked to present that, you will adopt it, and you have a margin of 5 minutes to present it and adopt it and summarize it. And then any intervener or MAINPOWER or EERC will be free to ask them questions. I hope you understand the order that we propose. All right. So we will also want to let us know that even though it's a quasi-judicial proceeding that we are holding, our business rules say that we are not going to be bound by the strict rules of evidence. So certain things that would not be admissible in a normal court might be admissible here. We want to have as much elbow room as possible to ensure that there is fair hearing in this proceeding. And just by way of a background, before I call on MAINPOWER to present the position. Yes. Yeah, and just to tell us that after the interveners have presented and have been cross-examined, have been interrogated by MAINPOWER, by any intervener, by EERC, the commission will have a few more questions to ask the presenter from MAINPOWER, and so that will come subsequently. So what we do is, after the first appearance, he will stand down, and then we will call him up again for further clarifications to make sure that even his understanding is clear. And so, by way of context, the Commission issued an order, a tariff order to MAINPOWER on the 18th of July 2025. And obviously, the licensee was dissatisfied and has taken the lawful way out by exercising their right under the business rules by filing a petition with the Commission. So, we're here, it's not like an adversarial proceeding where it is they against us. We want to make sure that every misunderstanding is cleared and people have the opportunity to express themselves. One of the things I've been saying is, please, we are going to be strict on time. If we give you 5 minutes to make a presentation, make sure you use that 5 minutes. After the 5 minutes, we will insist that you stop. We will also insist on orderly conduct. We don't want people to jump up from anywhere and begin to talk out of turn. Please, and if that happens, we have security who will ensure that the right thing is done. that location. Yes, as an intervener. Thank you. So, by way of context, the tariff was issued on the 18th of July 2025, and the licensee was dissatisfied. He has exercised their rights under the business rules, and we are here because of that today. We have complained about several things. They talked about 5 major issues, but the 2 major players they've asked that the tariff order be suspended pending the determination of this hearing, of this petition. And they've asked that 2 alternative tariff proposals have been put forward. So they will present and you hear. And so at this point, we would like to call on the representative of MAINPOWER Electricity Distribution Limited to please take the stand and adopt the petition and yeah. GC. No.
Please repeat after me. Thank you. So repeat after me. I. Your name.
I, Dr. Ernest Wire.
Sorry. Let's start afresh. I,
Dr. Ernest Mpwaya,
do solemnly swear
that the testimony
I shall give in this petition hearing shall be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you.
Okay. Just a minute. The affidavit that we received recently was sworn to by somebody else.
Dr. Chinet.
Yes, sir.
Yeah.
Yes, sir.
Yeah.
So,
we are going to make a presentation by 3 people, myself, Uche, and Chinedu, within that 10 minutes.
so I think that he adopts the evidence and then we come to support what he has said, then it is sworn separately. But he is the deponent on record in the affidavit that we have.
Okay, first we do the adoption.
Yes,
and then
yes, let him adopt and then whatever you need. But when you have taken it, so when next you come, you don't need to take oath.
Okay.
So it is only the other people that need to take oath. So, GC, we collect ourselves, let the document on record come forward and adopt the position and speak to it. So we have found that you have 3 representatives. We suggest that you don't use the 10 minutes, you use much less. You use 4 minutes and then the others can use the rest.
Thank you. Can we start?
All right, thank you.
I
I, Ilofo Trusting us, Chinedu.
do solemnly swear
Do solemnly swear
that the testimony I shall give
that the testimony I shall give
in this petition hearing
in this petition hearing
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Amen.
So, you have the house.
All right, thank you. Honorable Commissioners, the MDs of EEDC, MAINPOWER, and the public.
Your 4 minutes is going, so please go to...
Please, this is a petition brought because the tariff that was approved by the Commission has some identified issues.
Yes, please. So let him adopt the petition. Have you adopted the petition now?
Yes, I have.
So what we have, please confirm the affidavit, and then you have the petition proper. You adopt them as the petition and the affidavit in support from MAINPOWER. Is that right?
Yes, absolutely,
Okay.
sir.
All right. So I think you can take a seat, and the support can now take. Yes.
I want to swear you on oath, sir.
Any problem?
Okay. I just want to present our petition.
Yes, but you are giving evidence. So you take oath that you're going to.
No problem.
I
I, Okala Onuka Uche, do solemnly swear that the testimony I shall give in this petition herein shall be truth, the whole truth, and nothing but the truth. So help me God.
Amen.
Thank you. The panelists, the intervenors,
Go to the point. Go to the point.
and members of the public, we, MAINPOWER, presented a petition on the 1st of September, dated 1st of September, but received on the 9th of September. The gist of our petition is very simple, that we presented for a tariff for Enugu State. And in the tariff, the procedure for the tariff is very simple. One, the tariff model, financial model, will be given to the licensee, in this instance, MAINPOWER. So when it's given to the licensee will plug in his data, the parameters are being used. The methodology, tariff methodology regulation requires that when it is done and received by the Commission, then the Commission will call for bilateral engagements. That bilateral engagement happened between the 2nd to the 4th of July, 2025. Now, the outcome of that engagement shows clearly that there was no agreement. There was no agreement signed anywhere on the key parameters of ATC and C loss, of how we treat the regulatory asset value, the quantum of energy, the base energy that will be used, and every other key parameters that determines tariff, so that those who make investment, in this instance, MAINPOWER, can recover. Now, after that engagement, it yielded no agreement on those key parameters. And the tariff methodology regulation is very, very clear, 2024. If it does not, we don't have any agreement on those key parameters. The next thing, or the next port of call, is for us to have a formal hearing in line with the business rules before the tariff is approved, not after the tariff is approved. Now, what happened is that after we had that engagement from 2nd to 4th, it was a very rigorous engagement, from morning to night, for you to know the intensity of what we are discussing. Now, after that, We didn't get any other, because it was very clear we didn't agree. The next thing we saw tariff published on the 18th of July. So what we are saying in a nutshell is that the process was not followed. And there's no process that is perfect. There's no any human thing that is perfect. So we presented a petition to plead that let us cancel this process and look at those. Let's cancel the outcome, because the process is as good as the outcome. Because fair hearing has not been done under section 36 of the Constitution. And under section 7 subsection 3 of the business rules, the commission, when it involves our rights of any licensee, must do everything to consult and hear that particular licensee. And what we are talking about here is the epicenter of our business, which is the unit price we charge for what we serve. And this is coming from the grid. What we are serving is coming from the grid with manifold implications about remittances back to the grid so that the grid will not collapse. It's not only here in Enugu where it is. So it is a solemn issue and it has to be approached solemnly. Because the unit price also have been set by the regulator according to the generation companies that plug into the grid. So that's what we are asking for. That let us look at this system. The commissioners are wonderful. The discussion we had on those bilateral days were very, very insightful. It was an eye-opener because this is the first time it's been done and they were about to make some mistakes. And the issues that are involved are very technical, we must say. It is not what you readily bring to the members of the public. And that is why the methodology, the tariff methodology regulations spelled out very clearly, this is the process you follow. That's the only thing we are saying. On the ATC&C laws, as I mentioned, the commission is setting it at 24%. And said it is adding 4% with what is happening in the one we have at the federal level. And we are saying, no, that is not what our own yields. And the sensitivity of ATC&C laws for those who are expert and the discerning mind in tariff making knows that it has great, huge impact. We can have a discussion around it. Because this place has been ring-fenced out of the entire federation. Even what happened during the privatization, what happens in the privatization period is that you do a baseline study to determine those losses.
Mr. Okala, I hope you are looking at your time.
Yes, I will soon round up. Then the issue of not using the regulatory asset value for other members of the public who might not be initiated into what we are talking about. Regulatory asset are the totality of asset that is required for you to provide service. It is not what the consumers will be bored with, but these are the burden we carry as a service provider. So the regulator accumulates it, and the value, it gives value to it. Those investments made, the initial property asset you bring in, investment made, minus depreciation as it goes. And we are saying at the federal level is 3 trillion. At the EEDC level is about 200 and something billion. When you use 30% of energy, because 30% of energy goes to Enugu, when you use that 30% of energy, you now come down to 60-something billion or 70 billion. But what we're having is 29 billion. We have a major disagreement on that also. And so many other parameters which we have adopted, including the quantum of energy. Historically, we have never gotten to 129 million units.
Okay, how many more minutes do you need?
Okay. The regulator should, how many minutes?
You've actually exceeded.
Okay, let me just round up. So what we are saying in effect is that the process was not followed. We can come back and look at all those things and approve it. There's no adversarial situation we have here. We are one family to provide service to the customers. Thank you so much.
Thank you, Mr. Okala. Okay. So we have had the first representative. We have had the second representative from MAINPOWER. We're expecting that Dr. Mupraya should please take the stand? Sorry? How are we? Sorry, Chinedu. MD, you are not presenting again? All right, please do that. We want to make sure that you have an opportunity to say all that you need to say.
Hello. All right. Thank you so much. I just want to draw attention to just something very important. If we go by the energy submitted, because if you look at the petition, we have 4 key areas we talked about: the energy, the ATC&C, RAB, and OPEX, which my colleague, the barrister, the regulatory expert has talked about. I just want to talk about the energy. What's the energy? We have a historic data. Please, this one is disturbing, is interfering with what I'm talking about. Can somebody put it somewhere else? Okay. All right, I'll try. All right, thank you. I will try to assume I'm not hearing myself echoing. So, in the data we submitted, which my friend here, Ikenna, can attest to, we had a proposal where we said in our first year, we will target an energy of 80.35 million units, which is absolutely way beyond the historic average of 68, 67, 68. But we had that ambitious target of 80 point. If you check that data, we submitted 80.35 million units for the first year. It was surprised that when they returned and when they released the tariff, they actually deleted our first reference energy and went to the subsequent year, which can never and has never been anywhere possible for the company to actually implement, which is 94.96 million units. If you take that into gigawatt hour, of course, that is 1,140, which is in the model you published. That energy, actually, I'll tell us what that has actually done. Going by their simulation, we have an average tariff of 111.04. Okay, if we refer to the initial energy, the energy we actually submitted, if we run that with the same simulation you have, not changing the RAB, not changing the ATC&C, you have an average tariff of 117.33. That gives us an immediate shortfall of 6.29 kilowatts naira to a kilowatt. That means that by that singular mistake, the organization, instead of, if you run your simulation where you got 160.4, you will have 198.58 just by using the energy and also leaving every other thing you have left in that model. So that is one of the key issues we identified. In fact, the gap, when we say we have a gap of over 1.3, 1.7 billion, that is the fundamental area, and it's something that we consider that is a grave oversight that we should actually look at if we actually want to move forward, because this is the reality. You cannot assume we have energy that doesn't exist anywhere. Thank you. There are several other areas that we can talk about, but I just said let me just emphasize on this energy before we can talk about other areas. Thank you so much.
Thank you, Doctor. Thank you. So I don't know whether Dr. Mupaya would take the stand at this point.
I believe I saw already. I'm on oath. Okay, thank you very much. Let me start by saying a model, particularly in tariff model, a model is a tool for decision making so that you apply assumption and simulate what is going to happen on the ground. It's a very useful tool. But the fundamental issue about models is that the inputs must be very accurate. If you put wrong inputs, you get a wrong output. And a model can also be abused. Somebody can work backwards from the answer and tweak the inputs so that, it jives. So the issue of ensuring the assumptions are correct is cardinal. In our submitted petition, we have demonstrated the variance between the assumptions that were computed by NEC, computed by ourselves, and the assumptions that were used by the regulator. The 4 key assumptions are totally at variance. And the unfortunate thing is that within the 4 days of negotiating, we were not able to reach a landing. Because of that, this is where we are. Now, because we want this matter to be resolved in a very fair and transparent way, we had in agreement with our regulator to get an independent consultant. So we procured an independent consultant who has just issued this report. Is going to be shared if it's a part of the evidence. It's important, it's a useful input into the decision making. So, this report too is also showing some variance pointing into a direction of inaccuracies in the assumption. The first thing is we must recognize what are the accurate assumptions. Then we land at a tariff. If that tariff has got issues in terms of availability, it's another discussion on how the shaving will be done, both on the utility and the customer side. Because we're in business. We are not in business to drive away. In fact, I must mention that we have a very ambitious growth plan to support growth. Because we have done our market survey, Enugu is growing at a phenomenal rate. And we must also not only grow the business, but grow towards 24/7 supply. We want to put away, those days of a transformer is fault and then we are struggling to have a transformer. No, give us enough resources. And having worked for over 30 years, by the way, I'm a former MD of Zambian Electricity Supply Corporation. It's the 3rd largest utility in Central Southern Africa. Number 3 from ESCOM, Angola, and then Zambia, out of 11 subcos. And I'm also former MD of AEDC. I'm AEDC in Abuja. So I am both trained as an engineer and a business person. That's what I read. And coupled with my experience, I think we've seen enough to be able to transform a utility like what we are facing now. But the correct thing must be done. Just to speak very quickly about the findings of the independent consultant with KPMG.
MD, sorry.
The imported energy.
Please,
Yes,
MD,
yes.
MD, I think there's an ambush here. There's an ambush. You want to present something from the consultant that is not part, first, it's not part of what you submitted. 2, we're seeing it, you were just mentioning it this morning. How are we supposed to respond?
Okay. Can we just tender it in? I will not submit it, but can we tender it in for your review?
All right, so
Yeah.
for whatever is what, but yeah,
It's important that we tender in.
okay, but just to
Well, there's nothing wrong in tendering it, but the idea of having these things deposited earlier on was also for interveners and the Commission to look at it. But since it is not done, we're not going to reject it. I will advise you tender it. Then when we will be probably coming up with petitions, we'll also look at it to see what you have there.
Thank you very much. I think that's fair. We'll submit it. Every relevant information is important to this process. At the end of the day, the business must be sustainable. If the utility is shortchanged, it means all those grand plans for transmission will not occur. We'll now start having a poor service, blackouts, and so on. The very thing we want to address in our business plan. So this is a serious engagement where we must weigh both sides. the affordability issues, and the sustainability of the business. But at the core of this is to ensure that the assumptions are fair and correct.
So MD, sir, what will happen is you will tender it, we will admit it, but you will not speak to it now.
I'm not speaking.
So please, let's have a copy and let's formally admit it, and then it will become part of the proceedings. Am I right?
Correct.
So please, can we get a copy?
Yes.
Let me also probably add that at the end of these proceedings, there is definitely going to be a judgment. And then since it's a document you are tendering, we are receiving, it will also be looked into. But it is not something we can start talking about now because other people have not had opportunity of looking at it.
Fair enough.
Okay.
Fair enough. Because of the constraint of time, I must admit that the consultant worked very hard, but the time was not sufficient. But it's fair that we submit it in and you look at it, and if there are merits, they become part of the decision.
So is this something we get now, or is this something we submit later?
No, we have a clean copy. We can submit it later, a clean copy.
When will you submit that?
Today.
Today. Okay.
Thank you very much. I think I can end here.
Thank you.
Yeah, thank you.
So what we're trying to do is we're trying to make sure. So thank you, MAINPOWER. You have adopted your submission, and you have explained through three different representatives. You have explained your position, and we would ask the intervenors present. We have 5 intervenors on record. We will ask which of the intervenors has questions they would like to pose to the representative of MAINPOWER. Let me start with man is not physically here. I think I'm right. So EERC is here. Do you have question for MAINPOWER? Just yes or no? Do you have questions for them? No. So if you have question, we can take it now. So okay. So a representative of SECA, you have questions? Okay, please be on standby. And the representative of NECAI, do you have question? No question. Sorry? Are you two SECAs? So did you get an approval from us? Did you apply? Were you approved? Sorry, just a question. Did you apply to be an intervener? Was it approved? So that means you are not approved. Sorry, please. We need to be orderly. Did you sign our non-disclosure agreement? Did you? So that means you are not. Sorry? We are saying that it is only those that are formally approved. It was advertised in the press, 2 newspapers, and it was, sorry, sir, it was those that were approved that also signed our non-disclosure agreement that are officially here. So if you have not got a formal approval, if you have not executed an NDA, then you can't be here. Or you can be in the public and listen, but you can't have an audience. You don't have a standing.
Please, let us be orderly. We're not here to make trouble or do politics. Let me probably add that. We published in the newspaper the processes for this program, which definitely I'm sure you should be aware that you are required to apply to us for approval because there are certain conditionalities for approval. It's only those that applied and were approved and were actually made to sign a non-disclosure agreement that are recognized by the Commission as intervenors. So invariably, we are not supposed to be sitting there as intervenors. It's a space preserved for intervenors, so you can go to the space for the public.
Thank you. All right, so we have confirmed that SECA has question. Which other organization is represented there? I think that's all. So the representative of SECA, please, can you you please step forward, come to the stand, and ask your question. Who are you directing the question? Are you directing it to any particular representative of MAINPOWER, or all of them? Any one of them you can ask.
When they are presenting, they will do that. He's asking questions. When he's going to present, that will swear and vote.
Good morning. My name is Barrister Alex Amujogo. I represent Sika. I have okay. My first question that I'm asking MAINPOWER and the witnesses that has already made a speech before this panel is one, from their analysis, you will agree with me, the general question I'm asking them. You will agree with me that the petition in which you made for tariff review order, which was made on the more than 21 days, that the petition you brought was brought out of in breach of the business.
So, are you asking a question or are you making a submission?
I'm asking them a question.
Please, you are not a counsel, so please.
I'm putting to them.
Ask the question, but don't make a comment.
I want to put it to them that they will agree with me that the petition that they have brought against the tariff order review was brought outside the 21 days under the business rules in which the tariff order was made.
So that's the first question. Okay, please, we need a microphone for... Do we have a spare microphone?
Okay, the question you asked, in fact, it's a comment, it's not a question. Eh? It's not a question.
Are you agreeing with me on that? That's what I'm asking you.
You cannot even be saying that I agree with you.
Witness.
You're supposed to ask a question. But for your information, the petition was brought between because we are not here for technicalities.
So,
this petition was brought within the timeline.
First
of all, listen to me very well. First and foremost, we filed a petition on the 15th of July, 15th of August. So the commission wrote back to us. Are you listening to me? I want to give you the facts. The commission wrote back to us that we should amend the petition, remove the parties, and refile the petition. So we were given time, and we did that. That's why we refiled the petition on the 9th of September. So
lawyers are some of the worst witnesses.
Is closed.
So you have answered the question, but lawyers are bad witnesses. So please, I don't want the two of you to... so ask your second question.
I also put it to you that from the submission you made, you will agree with me that there are several meetings, discussions, exchange of data and documents before EERC made out the tariff order in line with their mandate, thereby not breaching the right of fair hearing, as you are claiming.
There's no question again. You are just fishing. And I want to answer you because we are not here for technicalities, as I said. Our case is very simple. If you have thoroughly read the documents that relates to what we are talking about, we have tariff methodology regulation. All of them were passed in 2004. No, 001, 002, and continue that way. If you have read it properly, what we are saying is that the community reading of this document I've mentioned now and the business rules, the process is very simple. One, there will be a model given to us, which we are publishing. You have mentioned it here. Two, there will be a bilateral engagement. Why is it bilateral engagement? Bilateral engagement in the sense that you that is here, if this issue of tariffs is being discussed, it's very technical, you can't hear anything we are talking about. After that bilateral engagement, which we had between 2nd to 4th of July, the next port of call, the next thing to do under that tariff methodology regulation 2024 is to have a formal hearing before a tariff is announced. Not, you don't have that tariff announced and now start having formal hearing. That's what we said. So if you don't do it that way, the fair hearing becomes an issue. Are you getting the point? And he said the hearing will be in line with the business rules. But that tariff methodology regulation is a special document that talks about regulation relating to tariff. Yeah. The business rule is a general provision. A general provision cannot override a specific document. Okay. Who has spelled out how you do it.
Mr. Kala, I think you have answered the question.
So, thank you.
Thank you. Yes, Leonard Council.
Just final question, please. Just final. And final.
When a lawyer holds a microphone, there's a danger.
Please, so, I want to ask you briefly, once again. In the course of presenting your data to EERC that was used to determine the tariff methodology, where from your submissions did you include the concerns, efforts, and the actions of the consumers who also assisted in raising the asset base of MAINPOWER? Where did you consider their interest?
That's the question.
Again, this is not, you are not asking a question. It's very simple. All the interest of every person is factored in, including the service provider. It's a symbiotic relationship. If we don't have money, we can't make investment, you won't be there. All those things are factored in. Look at the tariff, what we have proposed, everything is factored in. We want a situation in which we deploy meters, close the metering gap in Enugu, and serve you better. All of them are there. The Commission can attest to that. So
all right.
So
thank you, Lord Council. So that is that for questions from interveners. So we move next to interveners that made submissions that were received by both the Commission and by the other stakeholders that went into the folder. So I think Sika made a presentation, made a submission to the Commission. Are you ready to speak to it now? Are we ready? So please step forward. Somebody who is going to do that, step forward. Meanwhile, the representatives of MAINPOWER, please, you are on standby. You're on standby. When they finish their presentation, you have right to ask them questions. And GC, please. No, they are in the folders that you have access to. They were uploaded to the folders that you have access to. The Google folders, we sent the links to all the interveners and especially MAINPOWER. Please go on.
I, Chukwu Patience Ifebuche, do solemnly swear
that
the testimony
I shall give in this petition hearing
I shall give in this petition hearing
shall be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Amen.
Okay, so you made you made a submission to the commission. Please, can you speak to it?
Yes. Good morning,
You
everyone.
have 5 minutes to summarize your submission, and then other stakeholders can ask you a question on that.
Good morning, House. Basically, when this tariff review was done and the order, we, the consumers, were very excited about it because the high tariff has been a big burden on every consumer, both in Enugu and in the whole nation, both in business, in your personal affairs. So hearing that there's going to be a cut down on this tariff was really received with utmost joy in the whole state. Now, when the MAINPOWER talked about fair hearing, it happened to be that when the matter came up, we saw it on the TV, on Afia TV, when they had received the commissioners of the EERC, where they came and discussed the matter, saying how the data and all the records were shared between themselves and the DISCO MAINPOWER of Enugu State. And when we saw that there is, they said the licensee says that there's no fair hearing, but you were at the meeting. And while you are in discourse, just like every other meeting where you and someone are having a discussion, you can see the tone and see the body languages and hear everything that is in the meeting. But to come forth after the decision has been made to say you were not in agreement, to say the least, it doesn't really spell much about such discussion. Going further, talking about this loss of earning. When they say they had a lot of loss, the consumers have always been at loss. In fact, it's our savings that are used to pay electricity bills. It's equally the savings of the consumers that are used to buy the equipment. So when you say you've lost some earnings, the consumers are the first stakeholders in those assets. In those the assets and the equipments of the DISCO in Enugu State, there's no community who will say they're not bearing the burden, who were not taxed by the staffs, the member of staffs of the DISCO to bear the burden of these assets. If the transformer of your area is spoiled, the people begin to raise this money and buy this equipment, whether it's cable or it's the poles or whatever it is. So when you say you've lost, who is going to pay us? If you say you're seeking for a redress for the commission to pay you 1 billion, they are owing us a lot of money as the consumers. Who's going to pay us for all the losses and everything that went down the drain, and the generators that were burnt and the fuel during this whole matter? Now, when you say about this tariff order, well, for we the consumers, we cannot but adopt and support that this tariff should stand. And just like in our conclusion, we have said it, that the 160, yes, if there should be a review, it should just be, we are trying to be magnanimous as the consumers who have always been at the blunt side, to say 165 minimum or maximum is what is very okay for we the consumers, for every other thing we want to do. And finally, we also had this NEC trying to go beyond their jurisdiction, where they know that the state is already empowered to give such orders, and it should not be flaunted. Then lastly, for the DISCO MAINPOWER, I think, first of all, it should be obey before you complain. And there should have been an obedience in the first place, where there should have been some time. But what we saw was a whole total collapse of the system, where nobody was able to purchase even energy, and even the one you purchased, there was a whole lot of losses and stress on the part of the consumers. So I'm really adopting this submission of seeker, and we are saying that we support this tariff of 160, and if there should be any review on it, it should be more than 5 kilowatts per hour, making it 165. Thank you.
Thank you. Thank you very much. So don't go yet. Don't go. Don't go. Don't go. I don't know whether MAINPOWER or EEDC has a question for her. I don't know whether the consultant has any question for her or any intervener. If you have any question for her, please let's know.
We also have
sorry.
Yes, the document that was also submitted of purchase, transformer purchase, part of the assets which the consumers were part of.
Okay.
It was also sent, and they are also privy to those documents on the folders that were sent to them.
Okay. Can we assume that MAINPOWER had access to the folder and that you saw these submissions?
Yes.
Okay. So if you have any question for her, please can we let's start with MAINPOWER and then the interveners. If you have any intervener with a question for her, none. Okay, please pass the microphone to yes. Wait, he's with them.
Thank you very much, Mr. Chairman. We actually have clarification to make on the submission. And I think it's very important for all of us to understand that in this power sector,
Please ask. You have 2 questions for her, not comment. Ask her questions. 1 question, 2 questions. If it's a comment, no. Please. Questions.
Mr. Chairman.
She made a submission.
Yes.
And she adopted it. And the rules we established here is that after an intervener has adopted the position, people can ask them question. Now, if you have a question, you can go ahead. But if you don't have a question, I think you should sit.
I will do it in form of question. Madam, please, do you understand the meaning of ATC and C losses? Aggregate technical, commercial, and collection losses. That's one of the issues based on your submission. Can you tell us, do you understand that, so that your submission speaks to issues relating to that?
Yeah.
ATC and C losses.
All right, please answer the question.
That's my question number 1.
Now, when you ask if I know the meaning of that, I think in the last workshop, those were really spelled out by the next tier group, where we saw a lot of variations on those losses and on the feeders and all these assets that were shown us at the workshop. So, yes, to a point, I do. Thank you.
Okay, please.
My
Next
second
question.
Do you believe that when it comes to selling any product, the landing price, the landing cost, the cost of production should determine the selling price? Do you agree? Any product, whether you are selling bread or electricity as a distributor of bread or a distributor of electricity, do you agree that the cost as which you bought the product. If it's bread you bought from the bakery and you are selling to the public, the cost of production, how much you bought it for, will determine how much you will sell it for. Do you agree, ma'am?
Yes, if I bought a product, to
Yes,
answer your
it's a
question.
yes or no. Do you agree?
Oh, yes,
Okay.
moderately.
Okay, so
Okay.
your two questions are done.
Thank you.
Thank you very much.
My follow-up question is, Just-
Wait, this is manpower, is that right?
Yes, just follow up.
Okay, so let us take your two questions, please. Your two questions.
all right. Please, I just want to ask, in your submission, you ended by saying 5 naira per kilowatt hour additional to 160. Is that based on empirical calculation or just speculative on subjectivity?
Yes, our conclusion, if there should be a review, if the order is saying it's 160, and we are fine with the 160, and if it is not okay, then if it should be reviewed at all, we are saying 165 should be a limit that is fine by consumers, even if it is still at a lot of burden to us. Thank you.
So no, they didn't answer the question.
second
Is it based
question.
on-
Yeah, this is your
is it based
second
on
question.
data? Any data reference to that to that submission?
Any data reference?
Yes.
All these data that have been sent to us, and even at the plus that is in the input, if you had actually read what our submissions were that were sent, you will see that it was tabled inside of it, even plus the federal government releasing subsidies and all that. So there is data along the line too.
Thank you. Thank you. So, without having any other question from interveners, no, we have had two shots. We allowed the EEDC to have a shot. We have allowed MAINPOWER to have a shot. So I think it's only fair that we move on. But no, Mr. Dunton was speaking for you. No, then on what basis did he speak? On what basis did he speak? Because it's not a staff of our licensee. So we take it that both of you are tied together. Thank you. All right. So I don't know, Consultant, do you have any question for her? Please, the microphone.
Okay, Ms. Chiku, thank you very much for your submission, which the Commission has extensively reviewed. There are a few issues we have with the submission, to the extent that the Commission is a quasi-tribunal of record, and decisions have to be based on facts, evidence, empirical information. Let me start by asking, how many customers do you have registered in your association as members?
How many we have?
Yes, please.
Yes, we have more than 1,000 registered when we said registered. And then we have like in our whole, well, that's for registered as you asked.
And then, so do you have these customers categorized or segmented to represent either the banding, which MAINPOWER uses, or different categories? For example, do you have them like band A customers? How many do you have out of the 1,000 that are band A customers? How many do you have that are band B? Or how many do you have that are residential, commercial, manufacturers? Do you have that information?
We have data based on the local governments and the wards, of which they have in their own units, their own data of the bandings. So we have our customers who are in all of the bands, and majorly we have them in band A.
Okay, it would be very helpful for us to have your customer classification and the number of customers within each one, so that it helps to understand the positions you're taking on their behalf. Do you understand?
Yes,
so it's
yes.
something we would like you to submit, hopefully in the next few days. Now, if you go to your whole documentation, I'm afraid the commission's accepted it, but it kind of didn't follow the processes in the business rule properly. But it's been accepted. For the bits of evidence you have given, so that it enables the court of record to actually say that what you're saying are facts, right? We'll also need you to provide us with those evidence. For example, it's not paginated as it should be, but under your loss of earnings,
Yes.
you speak to lives have been lost. This is very serious. Maybe I'll call it allegation at this point. It would be nice to have had the evidence of the lives that were lost. So
Okay.
that if you had 1,000 registered customers and perhaps 20 have died as a result of this, then it's important to have that. You speak about, and I think this is the third page, you talk about you would need the commission to perhaps compel a 100 billion naira compensation for trauma and damages experienced by the consumers. It will also be necessary for you to provide the commission with how this would be shared. So for example, if you say you have 1,000 customers, this 100 billion, what exactly will it be for and how will it be shared? When we go further down on your tariff order, one thing the commission will also want to point out is in subsequent hearings when you're participating, like there were rules that were provided,
Yes.
but the commission takes exceptions to where words that are not appropriate are used to refer to either the regulator at the federal level or any other participant here. What would need in that section is you talk about intentional, that MAINPOWER has not provided meters, but they have been providing estimated bills intentionally. Can you please explain what you mean by that?
Okay. What we mean by intentionally, that we've had consumers who have paid for their meters and they have not been installed. So we've had that countless of times, of which we end up going and writing to the commission to intervene, to help out, to get them to do the necessary, of which the rules of the engagement of this installation, because after 10 days of when the demand notice has been given and you pay, it should be installed before 10 days. But we see that, and anytime you go to the offices, you hear there's no meter. But well, the meter is there. When you go and you have somehow you want to talk to someone who knows, the meter comes out from nowhere. So that's why we say it's intentional, because so many consumers have been traumatized by that. And when you've been left in the period of not being replaced with your emitter, then you are supposed to pay outrageous bills which are higher than what your consumption is.
Thank you very much for your response. Can you confirm to this meeting the cost of the different types of meters your members require? So for example, can you tell us the cost of a single-phase meter today or the cost of a three-phase meter?
Yes, a single phase and the only a single phase and three phase. So the three phase majorly is 234,000. And a single phase about 127 or thereabouts.
For this evidence in your last paragraph on this second page, please can you also submit to the Commission in support of this paragraph a list of your members who have applied for meters and who haven't received them. Also provide the Commission with a list of your members who are currently paying estimated billing. It is very important so we can support what you're saying here.
Yes.
Finally, with regards to the additional 5 naira that you want included, do you have an idea of the building blocks of this tariff, how the tariff is arrived at?
Yes, well, I would say I know much about it, but based on informations, we've seen a whole lot of the data that went through to get this, including the costs of purchase from the TCN and others. So I think I'll be basing that on the privileges of the Commission and the discretion, and also on us, because we can't say that the consumer should be burdened or care about what the methodology should be all about. Ours is give us services and we give you payment. So it's pay for service. That's what ours about.
Okay, let's do one thing here, which is the Commission is actually here to ensure that the MAINPOWER remains in business, meeting
Yes.
their license condition. In that case, they must be able to recover prudent costs that they spend, and their shareholders must be able to get a fair return, right? So why that question was important is that for the consumers, the Commission must ensure that you actually pay the fair tariff. Can you please then provide some additional, not as in speaking, but in the submissions you're sending in, just some additional explanation on how the 5 naira can be spread out? Thank you very much.
Thank you.
All right. Thank you, Doctor. So, witness, you have not later than Monday to submit whatever you have. Not later than Monday. Monday is, I think, 20th. Not later than Monday. If you have any further information you want to submit. Thank you. Thank you very much. So, at this point, we have told the witnesses for MAINPOWER that they are on stand down, and that they will come back to interrogate some of their submissions. And so, so I don't know who will be taking the questions, but we would like to, answering the questions, who will be answering the questions, but we would like to ask a few questions, and the consultant will also ask some questions. So, I want to, my colleagues, all right, so I want to ask this question, please. Now, in a petition, you had 2 prayers. The first prayer was that the application of the tariff order should be suspended pending the determination of the petition. And now, the situation on the ground, rather, is that you have already suspended that tariff order, and you are applying 209 naira per kilowatt hour for band A since August 2025. So, I ask the question, have you not rendered the position of the regulator used? Have you not usurped the function that you have asked in your petition that we should do? Have you not taken over that role from the Commission? That's the first question. They need a microphone, please. Yes, please.
Okay, the question is that we asked for suspension in the order, and the tariff 209 has kicked in back. That's the question you're asking. Have we not rendered the
Can rephrase it?
The prayer we're asking for?
Yes, your first prayer is that the tariff order should be suspended pending the determination of this petition. Okay? So, but you have actually taken matters in hand, have actually suspended the tariff order, and you are applying and implementing your own tariff since August 2025. So I'm asking, have you not become the regulator? Have you not taken over the role of the regulator and rendered the regulator helpless?
Okay, my colleague will speak to the technical aspect of it. But what I want to say is that suspension is a positive act. We never suspended the tariff. We had difficulties, overwhelming difficulties, which we drew to the attention of the commission through letters. And we wrote back to the commission. We even had a meeting with the commission that this is the situation we are facing. We are having an entire network, entire facility underpinning the entire Southeast. That if we continue to do this thing, the entire Southeast will collapse. So it was on that basis that we wrote the commission that, Honorable Commission, this is the situation we found ourselves. So saying we suspended is a positive act to say suspension. We never suspended. The circumstances foisted on us. My MD can speak further to that.
Yes, thank you very much. I think Uche has adequately explained. When the order was issued, we complied almost 100% for 17 days. But as you will appreciate, we have a centralized billing and vending system to the extent that to apply a differentiated tariff just on one subco compromised the operation of that system because it was designed like that. And we had engaged a developer who actually cautioned that further tweaking could collapse the vending and billing system. To this effect, we wrote to the commission to say this is the difficulty we are facing and we are working on it with the supply of the system so that this can be disaggregated. That's what led to that. But this particular prayer in the petition is suspension of the order pending the review, which is different from what has happened on the ground. Thank you.
Okay, I just want to also add further to that a very simple question. If the tariff had gone up, would it have taken you, would you have still had some problems as you had when the thing was reduced?
If the tariff
have gone up, maybe we had sanction 209 or above 209.
Thank you very much. Even if the tariff had gone up, we would have faced, because the problem is related to applying a differentiated tariff on just one geography of an integral system. And that we are still working on to see how they can reprogram so that that feature is part of the system.
Okay, so this is a public hearing. Invariably, the public, everybody's hearing what you're saying. Yes. So invariably, what I'm trying to understand here, which I want to ask you, by the time, I don't know how long it's going to take you to get this fixed. Will you be able to refund the customers for the monies that actually you're supposed to have charged them that you didn't charge them?
We have...
Let me add to that so that you answer both of them. So because in your second relief or prayer, you proposed two alternative tariffs for Band A. The first one, you proposed 206 for Band A, or alternatively 194 for Band A. Now, but what is happening now is that you are on 209. So the question is, suppose the commissioner agrees with you for 206 or 194, okay? If that agreement is done, what happens to the over-recovery you've been doing for the past 2 months? How do you intend to redress the over-recovery that you have intentionally been having from August to this particular time?
Thank you very much for that question. The first question was are you going to refund the customers for the period for which you have reverted back to 206? That is the reason why in our prayer we say suspend, so that we don't run in that situation of refunding on a tariff for which we have issues, for which we have petitioned, for which we have demonstrated that is suboptimal and it will make huge losses. So that question can only be answered once you have made a determination on the prayer, on the tariff prayer. It's not something you can answer because we don't know, we are not assuming the outcome. Yes. Thank you.
Okay, so finally from me. So is it fair to say that Manpower will only respect and accept tariffs that they like? They will accept and implement. If they don't like it, they won't implement it. Is it fair to say that?
It's not fair because our petition is based on what we believe are correct assumptions. And we've put a prayer across to review those assumptions and prudent assumptions, correct assumptions, if they derive as tariff, we are going to respect that.
Okay, so Dr. Marilyn, please, I think you can ask whatever questions you have at this point.
Thank you very much.
But at some point we will take a slight break so that people could stretch their legs, but maybe we will be guided when we need to take that break. Okay, please go ahead.
Thank you very much, panel chair. And thank you very much, Dr. Mopuwaya.
Okay, please go ahead.
So Commission has actually reviewed your affidavit and the documents you've submitted. I think it's fair to note, first of all, that based on the provisions in the business rules, particularly when you look at 13.2, 13.4, 11, the challenge has been that you haven't quite complied with the provisions of the business rule in making your submission. Regardless, the Commission is still relying on the same provisions in the business rule to proceed so that as much as possible, we would have a fair hearing, submission of all the things you have done, and a decision will be made. Earlier on in your summary, you talked about 4 issues that you were raising. Will it be possible for you to actually mention the 4 issues just for collaboration with what we have here?
Thank you very much. I will start with the first question. You are saying that we did not comply with the provisions. I believe you are speaking to the timing of submitting the petition. Confirm?
No, I'm not speaking to the timing.
You are speaking
what I'm
to...
speaking to, section 13, it talks about
yeah, you answer that.
So when you go to the affidavit in support of petitions and the way your petition should be presented, it talks about the way you present it, the document you present or submit to support, so that when you have any claims, then it's upon you to provide the documents that would show these claims you're talking about. Because that way, the Commission can then make decisions that are credible, decisions that can actually withstand external scrutiny. So what is available here is that not meeting that. However, the Commission is going ahead with this so that we may still have to request some documents from you, if you don't mind, so that this decision can be based on evidence. So my question then is...
Sorry, I need to make some clarification since we're in the public domain. Speaking to those provisions, if you look at our petition very critically, you will find that it's an unusual petition. It does not have parties. So from day one, it was an unusual kind of setting, and the Commission indulged us. Even when we had the pre-hearing, the Commission said, okay, we didn't know that we should also file along affidavit, because we first of all file a full petition with the affidavit and everything, and the Commission said, okay, remove the parties, it's non-adversarial. So we wrote again to ask for clarification because we didn't know the procedure. But then if you look at the business rules, the Commission is enabled to tweak any process in order to arrive this without sacrificing fair hearing. It is very, very important. We mentioned that. So we now refined our petition. That was why I was addressing the factional SECA man who talked about asking question whether we didn't file within the period. So when we now prepare the affidavit, we again, because the procedure, we are not used to it, we again wrote the Commission, attach the affidavit we have. Does this meet what will be in the best interest? The Commission did not specifically respond to it, but we went ahead, nevertheless, to file this affidavit. To answer straight to the provisions you have alluded, you have mentioned, we are, in view of the circumstances of this hearing, we are in right track in filing this affidavit, and we urge the Commission to accept us that way. Thank you so much.
Thank you very much. Let me just say that I'm not sure this is about you speak, Commission speaks, you speak, Commission speaks. Because what is important, referring to exactly what you have said, your initial application to the Commission, you were referring to the Commission as a defendant. So it looked like it's now a case between you and the Commission. And so the Commission, by its letter, then requested that you amended that, because the Commission is actually presiding over or administering the contract you have with consumers. So it's you and consumers as against you and the Commission. That's why that was said. But let us proceed so that the things that you have not attached to your application would also be mentioned. And then that way you can see the things you need to submit and not just saying you provided everything. Okay?
Let me now answer the question you raised about the core issues in our petition. We've itemized them as 5 items, but I must explain that one of the items impacts on 2 of them. The first one is the issue of regulatory asset base. And in our petition, we've shown the variance between what NEC had computed and what EERC is giving us, and also explain the differences. That there's a difference between net present value and regulatory asset base. The second issue is on ATC and C losses. The actual ATC and C losses is in the range of 45. There is a history to this, so now we got there, but it's being resolved through a different process of how capping methodology should be treated. Otherwise, we should have been 30 or going into below 30 by now, if there wasn't an introduction of an order which introduced an artificial loss. However, one of our bone of contention is it is very strange, unless in mature utilities, to have a flat ATC and C curve. Normally for utilities, the curves are slanting. The reason being that you build in an incentive for performance, so that you have a target year by year. If you achieve this, this is what you recover. By making it flat, you are capping the tariff to the extent that the capping, the loss in the initial years may be too high to recover.
Sorry to butt in on
Yes,
you, so that we don't spend unnecessary time, because all of these have been detailed in what we have. The question is to mention, so that we can collaborate that with what our issues list is.
Thank you very much.
And that's because when you stood and your colleague, you said you had 4 issues.
Right.
But in our summary, we don't have 4 issues. So that's why we want you to confirm.
Thank you very much. We have 5 issues in the report, because the issue of Forex subsidy and inflation impacts both on OPEX and RAB. Otherwise, the other one is energy allocation. So if we put Forex and subsidy as one of the issues, that makes 5 instead of 4.
Okay, so let me confirm, because what the Commission has number 1, RAB, number 2, ATC&C, distribution loss, number 3, operations cost, operations, maintenance, and administration, number 4, inflation, forex, and subsidy, and number 5, energy allocation.
Correct.
Correct. Is there anything you want to add? Is there anything you want to add to this?
Yes.
Please, can you note what it is?
Yes, we can. Although
To mention what it is, not the description, so that we can, it's just to be sure that we have the same
estimated
issues.
capping methodology. Estimated capping methodology. Capping methodology.
Okay, so we now have 6. Let me also mention that the question here, which is the issues list, is to do with the building blocks. So that to derive your revenue requirement, the Commission had to work with you to iterate a CAPEX plus OPEX plus taxes, added that to the reasonable profit that you were supposed to make, which is the weighted average cost multiplied by the regulatory asset base. So why I'm raising this for clarity is so that in course of the review of the decision, right?
Just a minute,
You
please.
now raise this, and so this would have to fit in one of those.
Yeah.
It's just so
Consultant,
that we're
sorry,
clear.
just a minute. Somebody is allowing the phone to keep ringing. We asked from the beginning, please mute your phones, please. Because if we don't, we will ask the security to get you out.
Are you tracking with me?
No, I'm listening.
Okay, so what we're saying is, because building blocks, each of the inputs here, like you correctly mentioned, the input must be accurate. And so within this input, we now have to plug the estimated billing figures you want within it.
Yes.
Okay. So for the issues list, the summary again for the Commission is that on the 31st of December 2024, you made a submission. You made a second submission on the 7th of March 2025 by your letter and all that you submitted. And then on the 5th of June, you also made a submission of these parameters, right? Now, when we take the RAB, so you submitted on the 31st of December 28.7 billion. On the 7th of March, you submitted 28.7 billion, the same 28.7 billion. For the ATC&C losses, on the 31st of December, you submitted 37%. On the 7th of March, you made a resubmission of the same parameter. You submitted 30%. For your OPEX, on the 31st of December, you submitted 5.8 billion. On the 7th of March, you also submitted 5.8 billion, so that was consistent. For inflation, forex, and subsidy, there was no submission from MAINPOWER on the 31st of December or the 7th of December. For the energy allocation, on the 31st of December, you submitted 120 megawatts. And on the 7th of March, you submitted 120 megawatts. So these are the two things you've submitted. However, on the 5th of June, you submitted for the RAB 29 billion, for your distribution loss 25%, for your OPEX 9.3 billion, for forex and subsidy and inflation nothing, for energy allocation 130 megawatts. So this is as far as the summary is with the commission. So what we will then be needing you to hand in, maybe latest on Monday, will now be your estimated capping methodology for what you now want it to be. So finally, the two issues as the commission understands from your document is that you're contesting fair hearing and then you're contesting these parameters. Is the commission correct?
The two issues, the commission is correct. But the numbers which are being mentioned, some of them sound strange. We need to go and check those numbers. I must also say that the tariff, the process for this tariff application leading to the order had a built-in process where you start scrutinizing and ensuring that each assumption is correct for 3-4 days. But during the entire process, the numbers which we could defend as correct numbers were never admitted, leading to this process. So if there was some numbers before that, that process of 3-4 days took care of that, leading to the final submission as the correct numbers. It would be interesting, I should inform you that even from the point of view of the regulator, there were some certain errors which the regulator were able to admit, and they were corrected within those same three days or 4 days. Thank you.
Thank you very much. Please, can you, just for everybody to be on the same page, you have raised an issue. You said there's regulatory asset value and there's regulatory asset base. Please, can you explain the two and the difference between the two?
Thank you very much. The net present value, let me ask my accountant, is he? Do you want to give it a go? Yeah, please, just explain the difference between net present value and net.
No, sorry, not net present value. What you had said was regulatory asset value and then regulatory asset base, not net present value. Regulatory asset value vis-a-vis regulatory asset base. So if you can
it's the same thing.
Sorry?
It's the same thing.
They are the same thing?
Yes.
So can you explain to us what it means?
Yeah, what it means is, for example, how it's computed. There is a value when the asset was procured. There was a certain value. Between that time and now, things have happened. There is an issue of depreciation. There is also an issue of some assets being added on. Remember that the procurement was done in dollars. So there is some level of indexation on how has the dollar and inflation impacted on this value up to today. That's a value which you now get as a regulated asset base. It's different from a net book value. It's very different because the intention is that you must earn on a certain base, on a certain investment. You must have sufficient earnings to maintain that system and ensuring that the service does not deteriorate. So it gives out a different number, and even the formulas are different.
Okay. You will recall that you had submitted an asset delineation. And this asset delineation does not provide any notes. There's no explanatory notes to it. So what we have here is it possible to let him have the table?
I know it.
form?
I have a copy.
Yeah?
I have a copy of... Please go ahead.
So if we go to page 12,
That is, sorry, just for information, that is the neck delineation order, is that?
Yes.
Okay.
so for this neck delineation order, can you confirm when you submitted it to this commission?
Before we confirm the date, I need to qualify that this document was produced by NEC.
Correct.
Through a consultative process where state regulators gave part of the input.
Correct.
So in terms of timing, that process had to be concluded. And before that, I will explain further. Audits had to be carried out in distribution companies to arrive at what were the audited figures in the previous years so that they can confirm some of the inputs into the computations that go into this.
Correct.
Now, the issue was, there was a peculiar issue in the end of 2024 where IFRS introduced a fee, a very humongous fee to sign audits. So given the challenges in the sector, challenges faced by most discos, it was a huge problem. Discos had to come together and appeal to the minister to have a waiver. So this delayed all the audits, and since those audits are part of the process, that's what delayed the production of this document. However, the best time to plant a tree was 50 years ago. The second best is now. When it was received, it was immediately given to our regulator. And I believe it's never too late to look at it and the merits of it and consider it. Thank you.
Okay, so the commission is considering it, hence the question or the need for clarification. So when you look at page 12 of that document, it talks about delineation of non-balance sheet items.
Go ahead, ma'am.
Okay. So you can see that the regulatory asset value, which you've agreed is the same thing as the regulatory asset base, is 215.60. But the asset base for Enugu is 65.4, which is what you have requested to be plugged in as your asset base.
Correct.
And the regulatory asset base is that quantum of your asset that you use for your regulated business.
Correct.
Correct. Okay. If you go to the asset delineation in table 5, you would see there that for Enugu, so this asset delineation would be your total assets. Yes or no? Your total physical assets.
Yes.
Yes or no? Yes.
Go ahead, ma'am.
You haven't answered. I said the asset delineation
Correct.
is your total asset, your
Correct.
total physical asset, yes or no?
Correct.
Okay, so it's from your total physical asset that we can then carve out your regulatory asset base. Because you may have a total physical asset, but it's not all used for your regulated business. Yes or no?
Yeah.
Sorry?
Yes, that's correct.
Okay, so again, there is a challenge here because, like I said, this document is created by NERC. We're not disputing that. It's something that NERC has put in a lot of resources to produce. However, when you see like even audited accounts, you see notes to the accounts, right? But this document which you have submitted does not contain the notes. So it's impossible for anyone to understand how these calculations were arrived at. However, can you explain how possible it is that your total physical assets is 23.44, but your regulated asset base, which will be carved out of your entire assets, is 65.4. So your regulated asset base is much larger than your total assets.
Yeah, it will be answered.
Okay, in answering that question, first let me say that as a DISCO, all our assets is used for the regulated business. Then, in tariff determination, what is being plugged in is not the historical cost or the net book value of the assets, which is about the 20-something billion. What is being plugged in tariff determination, we consider what we call replacement cost of these assets. We treat it as, like MAINPOWER is a new business, we treat it as if this business is starting today, what will it cost to procure these assets at their state as it is today, because they are serving this business. So that is where RAB comes in tariff determination. And in doing that, you start from the historical cost of these assets, consider depreciation, then consider inflation, which comes to revaluation. Because if you revalue MAINPOWER's assets as it is today, we are definitely going to get something higher than this 65 billion as our assets are today. So this 65 billion is born out of at the federal level, because prior to MAINPOWER, we came from somewhere. At the federal level, the whole of our holdco's assets, EEDC's assets, is about 200 and something billion. The RAB, which considered the forest escalator and the depreciation. So when part of that RAB is being delineated to MAINPOWER as a subco coming from that holdco, that is where we got this 65 billion.
You haven't quite answered the question.
Okay.
The issues you've mentioned, I think it's best we articulate them on a whiteboard, because your definition of regulatory asset base is different from the Commission's own. But what is important now is to address this. Can you explain, that's the question, how is it possible that your physical assets, your total physical assets, is here on this table, is 23.44, and your regulatory asset base is 65.4. And for clarity, a distribution company can have assets that it's not deploying into the regulated business. It's not all the time that you would have this. So for example, you can have excess optic fibers and you deploy that to telecoms. And if you do that, that side of your business will not be under regulation with the commission. So that's why you have the concept of regulatory asset base within tariff setting. Okay, so can you just clarify the answer? How is it possible that your regulatory asset base, this is the fact here, is 23 billion is your total asset, and your regulator's asset base is 65.4. How is it possible?
For getting that 65 billion, the Forex escalator has been taken into consideration because, like I mentioned earlier, what goes into the tariff is the replacement cost. The replacement cost of these assets are considered, not the historical cost. The replacement cost. And in determining that replacement cost, you take some economic factors into consideration. That is where Forex escalator comes in. So it's Forex escalator that is being applied to the historical cost of these assets to get what is plugged in as RAB in the tariff.
Okay, let me ask another question in a different way because you still haven't answered the question. Because the challenge the commission has, right, is to see a company where ideally your regulator's asset value should be less than your total assets. So do you have a depreciation policy in your company? You do?
Yes, we do.
Is it possible to provide that policy to the commission?
Yes, we can.
Secondly, can you explain something so we can draw an analogy from this? How do you value your assets and how do you tag them? What do I mean by this? I'm just going by what you have raised now to be that for regulatory asset value, you then revalue them. Because the formula for regulatory asset value is very simple in tariff determination. You have an opening RAB. Sorry, do we have a sheet? Can you bring the sheet? Sorry, let me just, so that we are all on the same page.
Okay.
And I'll just put that in right. Can you roll that for me? You see, the reason why we need to do this is to be sure that MAINPOWER will get what it needs to sustain its license conditions. And so any error on that will be devastating. All right, that is why the commission has taken time to look at all these parameters. But for us to then use them, it must be something that is credible. So if you're looking at regulatory asset base, within the formula for determining revenue requirement, what you do is you say that revenue requirement, do you have something bleeding better than this? Okay, it's your CapEx plus your operations, maintenance, and admin, which you can call your OpEx. Yeah, plus allowable taxes. Then to that, you add a reasonable profit. The word is reasonable, right? Now, for you to determine what reasonable profit is, you're going to be looking at your weighted average cost of capital multiplied by your regulatory asset base, right? So you're trying to get your return, right? And so why are you weighting this? You're weighting it because you're looking at equity plus your debt. The cost of debt is interest rate. You agree? Okay, so this can be imputed. So this is what we're all looking at, is the variables that are going into each of this that we're looking at. Now, how would you define your regulatory asset base? So your regulatory asset base, you'd have an opening RAB. That's right.
That's right.
You deduct any asset that has lived its life. So you have fully depreciated the asset, so you deduct it. You add any new assets. And then we can have a closing RAB. Are we all in agreement?
Yes, yes.
So that if, fully depreciated is out. So if, for example, just so that is a lot clearer in figures, if we had an opening RAB of 50, and we had to deduct maybe 30, and we had to add new assets, let's say 80. So what will we have as a closing RAB?
That is 100. That is 100.
No.
From your calculation,
we keep
it's
this.
100.
Before we talk, we keep this, right?
That's 100.
That's 100. Okay. Because before we then see, so what Commission is looking for here is this closing RAB. And like we've seen in the table you submitted, there is a challenge there. Okay? Now, if we then look at a very basic illustration. So if we bought a Hilux that is costing 50 million in 2024, and you're depreciating it over 5 years, it means that the depreciation each year is 10 million over 5 years. It means that if it's on January 2024, then at the end of 2024, to start 2025, the asset you have tagged, the value in your books will be what?
That is 40.
It will be 40. We agree?
Yes.
Now, it means that this is 2025. In 2026, the value will now be 30. And the asset still has the same tag.
Yes.
Okay. I'm just trying to, so that we can all understand how your argument is.
I have something to say about this illustration.
Hold on. So this is a Hilux. Yeah? So that by the end of the 5th year, the book value is 0. Yeah? Okay. But the asset still has a value. Okay. But the book value is 0.
Yes.
And so if you were working it in here, that's the same way you work it. So what we are then trying to understand is it possible that given inflation and exchange rate, we know that in 2025, this Hilux might start costing 150 million, for example. Now, in your books, in your company, are you now going to replace the depreciation, and instead of it to be 40 asset value, it will now become a new value of 150? Because in 2025, you're now having Hilux selling for 150. Would you do that?
Okay, let me
answer the question first.
No,
Will you do that?
It's not a yes or no question.
No.
No, it's
No,
not
because
a yes
you have,
or no question.
See, because we have a policy for depreciation, because we have that, yes, right? The issue here is you have assets, you tag the assets. And I'm also speaking from experience. I was the MD of MBET. Okay. So the government has a policy, and MBET has a policy for depreciating assets and for tagging assets. So we will not wake up, and so will the auditors look at it. The Auditor General and the auditors auditing our books will not expect us that in 2025, because we are buying Hiluxes at that time for 150, then the previous Hiluxes we have will now change their value. So that will not happen.
Okay, can I make a comment?
Yes, you can, but will that happen? Will that happen in AEDC? Would that happen in MAINPOWER? That when you now buy a new asset, you go and change the value of the others?
Can I make a comment?
Will that happen before you
Like
comment?
I
Yes.
said before, we are looking at assets in tariff determination and manpower as a new business.
Okay, so
Yes.
So who is looking
Tariff-
at it? Who is looking at
We
it?
Manpower is looking at our current assets for tariff determination and Manpower as a new business, the baseline that will form our opening RAB as a new business. That's what we are considering.
Okay, so again, would you have done this differently? Because we'll then come back to the asset and the way the asset is done in electricity businesses.
For this analysis,
yes,
if there is an official revaluation of assets, considering the net book value, because when you want to revalue an asset, you consider what is the carrying cost of assets at the point of revaluation, which is the net book value. So when you do an official revaluation of assets, that is when you consider like that the Helios is selling in 2025 for 150 million, does not mean that you're bringing in the whole 150 million. If there is an official revaluation of that asset at 2025, then you bring in the value that comes out of the revaluation of that asset. Then that changes the depreciation because the new value affects the depreciation as well.
Okay, so what we're hearing from the side of the commission is that you have two issues here. Okay. So the first issue for us is confirmation of that difference. Okay. The possibility that your asset value will be bigger than the rest of your assets, right? Which your asset value or your asset base, regulated asset base, is 65.4. And your total assets is significantly less than that. I mean, because personally, I've never seen that. So now, if you're saying that, because there is no note to this, so you have not...
I can tell you, like what I said before, that 65 comes out of delineation. It's coming from somewhere. It's coming from 213. That is the total RAB of EEDC. And that 213 came as a result of, in 2013, when EEDC came in place, there was a revaluation by NAC where they considered all these things. Each year, they ask for addition of assets from the discos, which we submit to them. They plug it into the MITO that they have and apply depreciation. It's in the MITO, it's in the public space. It's there. What's the RAB of all the discos in Nigeria are? So this 65 is just a portion of that 213 delineated to manpower.
Okay, let's not carry on with this because the important thing here is at least Commission's been able to show you how it's thinking on this. And the important thing is for you to have heard that opportunity, as you said, you were not fairly heard before, even though this was not submitted earlier. Now, this document does not in any way provide any notes. So it's impossible, you're not the author of the document, so it's impossible again for you to be the one providing an assumption to it, because what has to be provided in evidence, this is a commission of record, is that this is what the notes are saying. So please, it's just to be clear on this, that there is a challenge with this. You still haven't actually accepted that it is not practicable for your asset, your total physical asset, to be less than your regulatory asset base. And in the event that you're trying to revalue your assets, okay, then there's got to be clarity as to how that was done and what the methodology was and whether it is prudent to be accepted. Okay, so that's the issue with the regulatory asset base.
Okay,
right?
my final comment on that is this. Since you said we are not the author of this document.
No, but are you the author? Not since I said. Are you the author?
Okay. What I want to say is this.
Thank you, madam. If you look at paragraph 14 of this document, it's a law. We can't change it.
Excuse me.
Let me finish.
Excuse me.
Let me finish.
So let's not start an argument.
No,
that will
it's not
bring
an
up other
argument. It's a
things.
clarification.
No.
There were
said,
consultations even with the state regulatory bodies before this document.
Is it possible for you to add? Your MD has referred her as the expert to provide a response. And we're listening to her as the expert. We have read that, and we can see in that it is a law. However, you would want to be sure that there is no error in a law. A law is made by individuals. And if there is an error in a law, then it is amended. And I'm sure you recall that at 2013, there was a decimal point error in the submission from EEDC. You remember that? And with all the uproar in Nigeria, we reviewed it. I was one of the people, there were two of us asked to review that, and we made that recommendation, and that error was accepted. So it does not mean that if there's an error that cannot withstand external scrutiny, it will be absorbed. It will not be. All it is that will be highlighted and errors are corrected so that we are sure that consumers, the tariff they received is based on components that can be scrutinized, that can be admissible anywhere. That's what we're trying to do. But so that we make sure that Enugu Disco can sustain its license position and the consumers can get what is just and fair. That is the balance the Commission is here to do. Okay? So what's the comment?
Okay, what we're asking the Commission in RAB is this. We can plug in the historical cost of our assets in determining a tariff for a new business that is just starting, just like MAINPOWER. There is need for asset revaluation because the historical cost of our assets is not truly representing the replacement cost of these assets as it stands today in the present Nigeria. So that is what we are asking the Commission as it relates to RAB.
I'm sure you also understand that in distribution business, right? Because it's a monopoly, then it depends on the regulatory regime. What you have here is performance-based incentive regulation, and which means that at the end of it, it may be that this was by what is called franchise bidding. And if it's by franchise bidding or any kind of bidding, it does not mean that at the end of your license, you still hold it. And in that case, there will be a decision from accounting perspective as to whether the revaluation, will it be based on historical cost? Will it be based on replacement cost? Will it be based on current cost? Now, all of this will be articulated in the notes so that when this is now submitted, then the Commission can actually align. So it's not a judgment call on the decision of EERC. It's not. It's just so that Enugu Commission can actually stand and confirm, I have imputed this because it's the right thing to do. So nobody is judging anybody here. It's just let us be sure that what we are putting into the model is such that it will give us what is just and fair.
Okay, and that's exactly what we are saying, that imputing the historical cost of these assets in a tariff that is obtainable today is not right by MAINPOWER.
Okay, so Enugu Commission is seeking to have the full notes to this. Okay. It doesn't have any notes. You cannot explain it. So can you please send us the notes at the end of this?
Okay.
Tomorrow, let's have the notes. Okay. So that the notes are certified as part of this document. Then it becomes a question of, we can understand that this is how this was done.
Okay.
So we have a deal?
Yes.
You submit it to us tomorrow, okay. Right? Remember, it's not you writing it. It is a note to this that will be fully certified by the author of it.
Okay.
Thank you. Okay, MD, can we articulate the second issue, which is the operations cost? So what we have here is that you had made a submission of 5.8 billion in December 2024, and you subsequently submitted 5.8 billion again in March 2025. And this was the figure that was upheld until the tariff order, which you have now decided to ask for a review upon, was submitted. And so that tariff order was published on the 18th of July, following your earlier submission. And then on the 5th of June, you did submit 9.3 billion. And you recall that the commission had sent you a letter and where it asked you to break down this, compartmentalize them or segment them into what is your human resources cost, what is your other operations cost and maintenance of your business, which you did. And in that, the commission then arrived at about 5.7 or 5.8. Do you recall? Do you recall that?
Of course.
Okay. And so in your petition, which is a bit surprising, then you're still insisting that despite having audited the 9.3 and together arrived at 5.7, that you still want the 9.3. So the question then is, do you want in this gathering for us to still go with 9.3, or do you wish also to make a final adjustment to 9.3, which, if that is the case, will it be possible to have that submitted latest by tomorrow? So the reason is this, so that in everything and all the parameters, let us be able to cure that first issue, which is you did not have a fair hearing.
Thank you. Can I comment?
Yes, please.
Yes, thank you very much. Indeed, in the whole process of scrutinizing costs, we had submitted 9.3. And in the process of engagement, there were some costs that the regulator disallowed, arriving at that total of 5.8. However, you will understand that the transition is very fluid. We are coming from one entity and getting unbundled. The process of unbundling fully, at that time there were some costs which could not be determined. There are some costs. Number one, we had a case with NBED regarding disputed interests. And that case now has been disposed of. We have an understanding. There is a bill there which we must pay, and we have a portion of that bill attributed to MAINPOWER. It must be paid ongoing now that the matter has been put to rest. Secondly, after fully being unbundled, there are some services which have to be optimized by being centralized in the HoldCo. I can give you an example of our bidding and vending infrastructure, for example. It is, in the short term, it's cost effective to have it the way it is, subject to those tweaking so that, we can apply our own tariff and nothing goes wrong. That's number one. Number two, there are services that call center, world over call center are outsourced. In fact, many call centers in America, they are residing in India. So a centralized call center is existing. There are similar such issues which ERP system is a company-wide system which has been running and we've invested money. There is a portion of that cost. So everything considered, we would like to submit a new number that reflects now the accuracy. For interest's sake, although we've been operating under depressed OPEX, from January to date, we will submit that from January to June, we have already spent on OPEX 5.3 billion. So it can't be that in a year we are given 5.8. It will be, the operations will be very, very compromised. We want to move away from what the speaker said, buying transformer, buying this. Empower us so that we transform the company. So we'll come back with a figure, new computation.
You have said in your paragraph 9 that the financial impact of operating at the tariff order the Commission had approved, which was 160, is between 1.3 billion and 1.5 billion, and that it resulted in a cumulative gap of about 6.98 billion over 5 months. Which months are these that the loss accumulated over 5 months? Can you confirm the months, please?
Thank you very much. This is a product of modeling, part of it is projection, projection. So I'll ask Dr. Chinedu to speak to the numbers and how this was arrived at.
Not the numbers, the months.
Yeah, the months.
The question of the
months.
The question for the number will come.
August to December. August to December.
August. You said over 5 months. August 22nd. Can you name the 5 months?
August 1st to December 31st, 2025.
Okay, MD. So how is that possible when you have not implemented the tariff?
That was issued before the implementation of the tariff. That's when that was issued. But now, the situation has slightly changed because of what we explained earlier.
No, let's be clear.
Yes.
Your submission is dated 1st of September. This submission is dated 1st of September. And in this submission, you are noting that you have had a shortfall of between 1.3 billion to 1.5 billion, and that this has been over 5 months. This paragraph is not saying that you will have, and it's saying that you have had.
No.
And so, okay, can you
It is supposed to be a projection. But of course, there are misalignment in the dates. Remember, the first petition was submitted, and then there was, it came back for amendments and so on. So there are misalignments in the date. At a time when the calculation was being made and presented to the Commission, it was a projection.
Okay, is it possible to submit, because again, that's why, like I said earlier on, that when one is looking at what you've submitted, it doesn't quite comply, because everything you've submitted, if you're laying claim on something, you submit that document so that it's possible for the Commission to then see how you're making. This is a huge number.
Yeah.
If you're going to have this huge number of loss, then the Commission is very concerned because you can't sustain your business. But it needs to see it. Just like we're asking the second lady, you don't just come to a public hearing like this, particularly where you sworn an oath, and you're giving information that is not accurate. So can we have that document? Can you send it to us tomorrow? Because it will have the assumptions you have. It will have how you came about this. So it's an existing document. Perhaps you can just give it to us this evening so that we can work quickly with it.
Fair enough. We'll submit our calculation.
So that is on the OPEX. In your chapter, your paragraph 9, we have other issues. In number 3, 9.3, you speak to the investment impact, and you're also laying some claim that with this new tariff, 160, then you will not be able to fund your capital expenditure of 33.2 billion. Again, this is also difficult to understand because just saying capital expenditure does not also allow the Commission to then see the breakout of this 32.2 billion. So is it possible, because you have it, can you also submit it so that we can see what becomes sustainment cost, what becomes new expansion, and what becomes operations? So that way, it's also easy for the commission to marry and say, this is exactly what you're talking about. With the metering is still part of your operations. So we wouldn't be expecting the metering to stand separate. So within the operations, you can just list them there.
Metering is CapEx. It's CapEx. It's very serious.
Yeah,
CapEx.
that's what I'm saying.
Yes.
This is CapEx. So when you then put them in that category, it's easy for the commission to know what is new investment, what is maintenance, and what is operations.
Right.
So that way is a lot easier. In paragraph 9.4, operational impact, you have also listed here that the tariff is driving away your customers, or will drive away your customers, right?
Yes.
Towards self-generation.
Yes.
Okay. Seated here, we all know that many customers have moved off the grid.
Many more can move out.
Many more will.
Yeah. If we
Right, but
continue
many
this
more,
way.
a lot have moved off the grid.
Many more.
Yes. So it's just so that we can support your claim here. Is it possible also to provide us with the data of the customers who have actually stopped vending, for example?
Right.
Because that way it will show that perhaps the tariff has caused them not to vend. In this case, you haven't applied the tariff because you applied it for only 3 days and not 17 days. 3 days by your letter that is here with us. You applied it for 3 days, not for 17 days. But we need to be able to support this as evidence. And in paragraph 10, you speak to authorities, legal authorities that you have relied on apart from your financial model. Is that, recall that the commission had issued you financial model. Whether some values were removed. Whether some values were. Okay. Sorry, MD. So here in paragraph 10, you speak about relying on financial models. The challenge is because we want to be sure of which financial models you are relying on. Was it the financial models the commission issued to you or a different financial model?
Both.
Both.
Yes.
But which one would be more appropriate in a commission-driven proceeding?
Yes, what is more appropriate is what a commission gave us. That's a model which we use to project the impact of that tariff.
Okay, because the challenge here is, as at 22nd of March, you will recall that the commission had sent you a letter where it chronicled the different figures that you had changed, your company had changed in the model, and some things that you had actually deleted. So I think what would be helpful is for us to have the reaffirmation of which model you're using, and then when you talk of legal instruments, again, it hasn't kind of stated the authorities you're looking at here. So it is maybe, will I say, presumptive that someone would then know what you're talking about. So that when all these documents are presented for a third-party guidance to the commission, I'm also then asking what is being referred to here.
Yes, thank you very much. Let me just add clarity. This model was prepared by EERC. It's a new model, which was served to us for the first time. And in trying to work with the model, we tried our best to work with the model. And then we had, an ongoing interaction with the commission. There are certain things which we had interpreted differently, and we were corrected to say, look, maybe these cells were not supposed to be deleted. At that point, we had a meeting, and I did request to say, this is not an examination. Let's have an open interaction to understand the model, because it's just a tool. It's not like you are examining somebody to pass or fail. And we had that session. From the time when we had that session, I think there were no issues about the model or which cell to be deleted. It was a teething problem of using the tool for the first time, and it can happen in any environment.
Thank you very much. I'd like us to actually, so we've dealt with the RAB, we've dealt with the OPEX. With the distribution loss, can you actually confirm what the distribution loss you're looking at consists of?
Thank you very much. And I want to, yes.
We take it that we've talked about RAB, we've talked about OPEX. So we're about to start with loss, is that right?
Yes.
So we're suggesting if we could take a 10 minutes, 15 minutes break, or okay, let's say 20 minutes break. 20 minutes break, if that's acceptable to all the parties.
It's acceptable.
No, I think that's fine, because after 45 minutes, the brain doesn't keep going, right?
So please, let's reconvene. This is, we're taking
so
okay.
1:30.
Although it's almost finished.
15 minutes. Okay, 15 minutes break will give us like 10 minutes after 1. Okay, so please, the proceedings stood down until 10 minutes after 1 p.m. Thank you.
You don't need to be told. It's DJ Wells.
If I could sound 1,000 voice, it's not enough to sing your praise. Mighty one, the great I am. There is no one else like you. You made the ocean deep and wide. You made the sky so beautiful. Only you can do these things. There is no one else like you. Can do these things. There is no one else like you. Oba, Oba, Blessed be your holy name. King of kings, Lord of lords, we honor you today.
You don't need to be told.
We declare majesty. You alone, no one else, forever you will be. Oh, oh, oh. Worthy, worthy, worthy is your name. Narekele, narekele. Great and mighty things that you have done. Narekele, narekele. Chineke, inimanesia. Narekele, narekele. For the great and mighty things that you have done. Yeah. Narekele, narekele. Chineke, inimanesia. Blessed be your holy name. Blessed be your holy name. You're the King of kings and Lord of lords. We honor you today. We declare your majesty. Oh, you alone, yeah. Oh, oh, oh. Worthy, worthy, worthy is your name. Keep my eyes on Jesus. Keep my eyes on Jesus. Yes, I keep my eyes on Jesus. Keep my eyes on Jesus. Oh, I keep my eyes on Jesus. Keep my eyes on Jesus. I don't want to see nobody else. I keep my eyes on Jesus. So I keep my eyes on Jesus. Keep my eyes on Jesus. I don't want to see nobody else. I keep my eyes on Jesus. I don't want to know nobody else. I keep my eyes on Jesus. I don't want to be nobody else. I keep my eyes on Jesus. DJ Will. Father, I love you with all my heart. Lord, you saved my soul from shame. Oh, thank you, Jesus. You came to die. Oh, you died on the cross for me. Now you will save my soul from death. Oh, for who you are. Oh, yeah. Lord, you picked me up from the merry clay. If not you, Lord, I don't know where I could be now. Oh, no. Now you will save my soul from death. Now you are. Now you are. Now you will save my soul from shame. Now you are. Now you are. Now you will save my soul from death. I remember when I was a child. I was sick every other day. It was so bad the doctor said I was gonna die young. But here I am today. Singing.
The session is being called back to order. Please, can we take our seats? The press, please. We need to take this outside this meeting. Please, we need to continue this session. We haven't finished.
Can we have our seats, please? Can we have our seats? Ladies and gentlemen. Can we have our seats? Okay, good afternoon, ladies and gentlemen. Once again, thank you for your participation so far. We are about to start the second session, and we're all welcome. And we are going to talk about the distribution laws at this moment, having dealt with RAB and the OPEX. So we will continue with Dr. Marilyn, cross-examining MAINPOWER. Thank you.
Okay. Thank you very much. Dr. Mopowaya, thank you very much. I asked before we left for you to kind of explain to us the distribution components of what you consider as distribution losses.
Thank you very much. There are three components that build up.
Sorry, the three components in these tariff submissions you made.
Yes. We call it ATC and C losses, which is aggregate, technical, commercial, and collection losses. That's what builds up as losses.
So
there's a speaker. It's pointing to that.
Can you put, it's yours off now? Okay. So aggregate, technical.
That speaker is resonating with the microphone. Let him twist it. It is the speaker which was.
Technical.
Yes. Aggregate, technical, commercial, and collection losses.
Okay. All right. So you want 45%.
I didn't say I would want 45, but 45 is a loss which we have now. We are beginning from 45.
You're beginning from 45? How?
I mean, the existing loss level is 45%.
So, because you've been given 25, but you want 45. So essentially, you're looking at almost 50% of what you're getting will be losses.
Let me answer that question. Among all the variables which go into the tariff input, it's fair to say that ATC and C loss is one of those variables where the commissioner has to do a balancing act. Because if they give a very low threshold, it means we will not have sufficient revenue to run business. If it's too high, it means that customers are paying for losses, which should be driven down by utility. So what we are asking for is a fair sort of demarcation on what we should work on. In fact, the best practice is to have a slanting trajectory, as I said earlier, so that every year the utility is encouraged to invest and reduce those losses. And the target moves on. It's a moving target, not a flat line. When it is flat like that, it indirectly, eats into the revenue we should have gone, or allowable revenue for the DISCO. And that can have repercussion on the quality of service.
Okay, so when you look at technical losses, how would you reduce technical losses? And
Yes.
how would you reduce, so let's leave the figure, but assuming you're grounded on technical losses, if you can explain what will this technical loss be and how can you mitigate it?
Thank you very much. Technical loss, we are referring to the distribution delivery system. Part of the energy is lost in the delivery system. The obvious ones is that the wires will get heated up, and you have an I-squared error, a technical loss being lost in the wires because of the inefficiency of the wires. There is no conductor which is 100% efficient. So whether you're using copper or aluminum, you are losing on the wires. Then we come to the equipment like transformers. Transformers have got core losses, iron losses and copper winding losses or aluminum. So those losses are real. We call them technical losses. How do you reduce them? You reduce them by prudent design. You design in such a way that the circuits are not being overloaded, and you control the flow of VARs in the system. For example, if you have low power factors and so on, you have a lot of wastage of energy due to VARs which are being transmitted in the system instead of being generated at a customer side using capacitors. So you control it by encouraging power factor correction and optimizing the designs of the power system. In fact, technical losses, they are related to the quality of supply. If a system has a lot of technical losses, it will translate into, cut conductors, it will translate to low voltages and so on. Before you even talk of technical losses, you will have the experience of a bad quality of supply. By fixing the bad quality, you are indirectly resolving the technical losses.
Commercial loss.
Yes, the commercial losses is a difference between the energy which you have received in the system at the level where you are transacting, maybe at a level where at a customer level, how much of that energy was translated into bills. There is usually a gap. That gap can be due to billing inaccuracies, can be due to theft of electricity. You have delivered X amount of units, but you have not been able to bill them because of those inaccuracies, theft, and so on. So it's at a level of billing that you have commercial losses.
Thank you very much. And this is the same position the Commission has in terms of your definition. So what we are hearing from what you have explained is that there's a relationship between investment in the network and the quantity or the quantum of losses you would have. Yeah. So for example, if you have devoted the funds or you have brought in shareholders investment and you're able to improve or optimize the design of your network to the extent that you then reduce the energy that is dissipated through wires, and you're effectively reducing the commercial losses, which is essentially the electricity you supply to consumers, of which they're either bypassing their meters or they're finding ways to tap into, which you're not collecting. Now, so the issue then becomes how the Commission can then concede that MAINPOWER network is so bad that it has to provision 45% as commercial losses.
Yes, it's an easy number to compute. Every month we send commercial information to the Commission, and they can easily compute that and verify what is the level of the losses currently.
Okay, so it then calls into question, right, the investment you've made so far, right? Bearing in mind that when the Commission looks at the EEDC, of which Enugu Disco has the second load in the southeast, right? And the investments that have been made or should have been made on the network, then the challenge becomes how to then say you can have 45%.
Thank you very much. I will answer that question. When the baseline study was done at acquisition, shortly after acquisition, the losses were in the upper 50s. And EDC has been working through investment, aggressive metering, and working on the infrastructure to drive down losses. Enugu specifically, when the Commission took over, we were at 32. And by now, our journey, we should have been in the 20s already. But this is again, there is a relationship between decisions and impacts. There was a decision made to move away from NEC estimated methodology for capping and another capping, which we protested, and that order by itself, because we must obey, it introduced an artificial loss, and overnight, our losses swung from 32 to the 45 we are talking about now. Now we have started another journey to bring it down.
Okay, so what you're saying is acquisition was in 2013.
Yeah.
Yes. Okay, and in 2013, the provisioned loss was 55%.
Okay.
That's, I'm kind of noting, reaffirming what you have said. It was 25% at acquisition. That's what you just said.
No, that's not what I said.
Okay, what did you say?
What I said is at acquisition, the losses were in upper 50s, close to 60%.
Upper 50s?
Yes, close to 60, and they've been driven down to that.
Okay, assuming it's even 60.
Yeah.
And 12 years afterwards, you then want this commission to now give you 45%.
You see, I didn't say give us 25, 45. And I need to be, listen to very carefully. I said the variable of ATC and C loss is one of the losses where a regulator has to make a judgment call. They have to look at what is the existing loss level and what is the loss level which the DISCO can be encouraged to improve on systematically over the years, because it's not something you resolve in 1 year. And typically, instead of having a flat 25%, would have expected to have a slanting curve so that every year you have an incentive a target which you must hit every year. It's not for me to tell the commissioner to give us 45. 45 is what is existing.
Okay,
what the commissioner gives us, if they give us a very low ATC like 25, it means we may not have enough resources to turn around the business. That's the thing.
Okay, so the commission is actually looking to give you what will help you to work.
Correct.
The only thing is that the commission has to apply, like you know, the prudence rule.
Correct.
And look at used and useful.
Yes.
But then in applying the prudence rule, the commission also has to consider that this utility or this infrastructure business, at the time, like you provided, it had about upper 60s.
Yes.
Right? Now, between then and now, and actually in the past few years, because you have something else here in your paper, you have made some investments. You have been allowed to take some loans to plug these commercial losses and also to plug the distribution losses. So from Commission's perspective, looking at those, the question then becomes, why will they then, 12 years after privatization, be then offering you 45%? There are instances where a utility might also be given a constant returns to scale kind of loss, right? But in this case, it's just trying to understand why would they then provide 45% and not the 25%? Why wouldn't they say, okay, we're going to take 25% and go down from there? So it's understanding that will enable the commission know exactly whether this 45% is still what should be allowed.
First, let's understand, let me make one thing clear. The 45% has got a component of an artificial loss induced by an order. You know, the position of commission is very powerful. You can actually make an order which can kill a company instantly. I said we are at 32%. By the order which was issued on capping, we swung to over 45. We are now struggling again to come down. If that order was not in place, this time we could have been talking of a figure below even 30, maybe 28. And 28 and 25 is quite close. That may not even have been an issue. We have been put in a position where an artificial loss has been applied. And now, because of that, what we should have earned, we are not going to earn it. And that's a minus into the resources to improve the service.
Okay, can we have some clarity on, because as it stands, a lot of customers have left the grid and they keep leaving. And a lot of people are putting solar panels on their roofs and in their residences. So when you look at your energy, right, that you're using for the transportation business, so where do you classify that loss of those customers who are not vending and who have clearly moved out?
Thank you very much. You have asked a very pertinent question, which I'll answer very well.
Because the issue now is when you're looking at the aggregate loss, is it the case, because from what you've submitted, we're struggling to find where that features. Is it then the case that that also is part of the commercial losses you're talking about?
Thank you very much. I'll answer that very well because it's a very common misconception. We are operating in an environment, a business environment of power deficit, right? Until such a time that we stabilize. So in a power deficit scenario, if you migrate from my network, your neighbor will get that power. So there is no loss. You cannot lose what you have not sold. But you have lost in terms of the market because the other objective to expand the market. But in terms of immediate, there is no impact on ATC and C if somebody leaves the network because the power will be consumed by another customer.
But what it has an impact on your revenue requirement because your revenue requirement is based on the quantity of energy you're transporting.
Correct.
So, sorry?
Yeah, so if it's
no longer available, then you can't actually recover the revenue requirement that's been approved
You
to you.
recover it because another person will consume that power. That product will be consumed. Remember, electricity travels at the speed of light. It's a dynamic system. If the neighbor decides to switch off the supply, the other neighbor will receive the electricity immediately. The only thing I have to make sure is that I'm importing sufficient to. I can even increase bands, allocation, banding. You start giving more hours of supply. So there's no loss. Yes.
Dr. Mupawaya, when you have, like you said, I'm just taking from what you said so that we can see how we can treat this loss. When you have a short-term constraint, because in electricity, capacity is limited on the short run. You can't increase the generation just like that. So generation, like you said, is not sufficient. But even with the sufficiency, your network points and the nodes are set. You can't move them. So if you're not now having the customers who are supposed to take electricity, for example, when you come to Abuja now, most of the people in Asokoro are going off the grid. Most of the people in Metama are going off the grid. In the industry here, it's happening. The banks are providing facilities for their customers to get on, solar panels. And so in that case, where you already have a fixed place where your energy comes into and the customers are not taking it, that's why we need some clarity. How do you deal with that? Because it means you can't equally recover your revenue requirement. And then it means that at the end of the day, where does that loss get bucketed into?
There is no such a loss. In an environment of deficit, there is no such a loss.
So the reason why I asked that question is in your submission, you speak about market shortfall. And I kind of got a bit confused as you're a company. So what is this market shortfall?
Thank you very much. Let me explain it. There is a fixed price for the energy we are importing into MAINPOWER. That price is set, at neck level. That price is fixed. And in this modeling, I must give it to them, the commissioners recognize that price. And they told us, look, if there is a new generator, they will adjust. However, what has been impacted on us is the price at which we are selling the product. If the price at which we are selling the product is reduced, our ability to meet that wholesale price is impaired. That's what we are talking about. The tempering is not at the price of energy. It's a price at which we are selling the product.
Okay, Doctor, just one. Dr. Mupawaya, please take your seat if you want. You mustn't stand to answer the question. Please, sir. Thank you.
I thought I've answered it.
Oh, you finished? Oh, okay. Okay, I'm just trying to pick your last submission because in your 9.4, where you're saying that customers are being driven away towards self-generation, right? Yes. You don't consider that the tariff is actually what is driving them to self-generation.
Yeah. This business is a complex business, and it's always dangerous to look at one variable. I will explain. Yes, the tariff does have an impact. That's why the tariff must be fair, right? However, there are other factors which can drive away the customer. If you should change the utility will fail to provide excellent maintenance on the infrastructure. Particularly industries, they are very sensitive to power failures, outages, dips, and so on. Just a 2-second, 3-second dip, a manufacturing process will be brought down for 8 hours. We understand these things, very well. So, if I don't have investment to start putting in new technologies, by the way, our business plan is such that some industrial clusters we want to put base battery energy storage systems, which can override, interruptions and dips, so that we give excellent service like anywhere else. If you don't give us those resources, those pains for the customer, they will face it, and they will try to go for expensive generation, diesel generator, which is more expensive. So the best is to empower a utility so that it improves the service because it's a least cost. Those who are migrating, they're not migrating because the generation is lower. No, they are migrating because they are fed up with the quality of supply. Thank you.
Okay, but if you have the fixed infrastructure where, like you have said, you have not quite made the investment, so it's fixed. But you're migrating from the information we have here, over 50% of your customers are now in band A, right? So in that situation, it's not really theory, it's just practice. If you have all of them there and the system is fixed, then the average cost should be lower. Do you agree? I can illustrate it.
Yes, go ahead.
It's applicable in electricity.
Yes.
If you have all the customers or the quantum of customers migrated to band A,
yes,
and the same customers and the same infrastructure, then the average cost should drop for that section.
Correct.
And if that is the case, then you would then see that with the simulation of what you've done with the commission, then obviously you cannot then begin to charge band A the same 206 because you've now migrated more people onto it. So the average cost will be lower.
Yes, let me explain this. It's not a step something, it's a journey. And that's what we had expected. In a transition, one has to be careful to manage the transition. You don't give it a shock. It's not just overnight from 20 watt, you have improved, you are now 106, you collapse the system. But a systematic improvement line by line and improving the quality would bring down the price. That happens even in telecom. Economies of scale, because you have more customers who are getting 24/7, close to 24/7. You reduce the price. That comes naturally. It's not a step function. It's dangerous to assume that this can be achieved overnight. Overnight, you make this. It's a journey.
Okay, we can leave this, but at least we've got some understanding that certainly when you have more people migrating into band A, then that cost should drop because the average cost should decrease.
Yes.
We have that understanding. Okay, so I think we've somehow found some understanding around what would be the investment and what will reduce distribution losses. And I think that with what you were going to bring for us, which is the breakout of your investment that will show us what is sustainment, what is new investment, and what is operations, we may be able from there also to see like your metering and things to then understand clearly whether the cost of 9.3 is justified and then the 45% is justified. Are we tracking?
Correct. Yes.
Okay. So let's look at the next thing, which is the inflation, the forex, and subsidy, which in your petition,
it's a small question, please, for MAINPOWER. Yes, MAINPOWER, they're in a position to know this. So what is the current loss that is allowed for EEDC for the rest of the Southeast? What is the current, whether you call it ATC&C or distribution loss? What do you have at the moment?
This question is to MAINPOWER or EEDC? This question is for EEDC? Okay. So
And you know that up until December 2024, you are all together
Correct.
And even right now, you are still together.
Correct.
You don't have a separate account. Everything is together. So they can answer. Please, sir. Dr. Boya can give us the answer.
Let me share with you to answer the question that you asked. If we look at the ATCNC loss levels, the rest of EEDC has a better improved loss ATCNC levels
Sir,
than Enugu.
Please tell me what's the figure that appears in your monthly supplementary tariff order from NEC. What is the loss that that's been coming up to? Yes, what's the number?
As of now, we are around 30% ATCNC loss levels across EADC.
Okay, let's take it this way so that we don't probably derail, because the Commission made a decision you are contesting, and it's also good for the public to know why these decisions were made. As of 2024, when you had loss projected for you by NERC, NERC had made provisions for investment in losses, which is intended to keep you at 2020 at 25% in 2023. And then in 2024, you are supposed to make improvement to 2021. Don't forget, allowance have been made for you. Sorry, 2021 to 21%, from 25 to 21. Allowances have been made for you in the tariff, which the customers were paying for you to make investments to reduce to 2021 in 2024. Now, you are coming to us in 2025 for tariff. We're not telling you that we will need to put you at 2025 flat level to enable you make improvements. If you finish making improvement and recover in 1 year, the remaining year becomes an incentive for you to make more money. Now, what is important, and which also what concerns the regulator, is don't forget we also have the customers to protect their interests, because as at the time you were given that 20-25% tariff loss level in 2023, NEC gave you allowances for making investment in CapEx to reduce losses, which the customers have paid the tariff. After the customers have paid the tariff to you, you are supposed to have reduced their loss to 2021 in 2024, but to ask you go to 25 and stay there for 5 years so that I have opportunity of making all the necessary improvements you need to make and make money. So if a customer has paid you money in tariff to reduce tariff loss and it is not achieved, it points to a fact that is provided for in the law that the operation is inefficient. And we are not mandated in any way by law to provide you money for an inefficient operation. So I'm only bringing up this thing to the fore because it is important that's also recorded that there are reasons the Commission took those decisions, and those reasons actually were because you were coming from a system that the same customers have been paying the money. There is no change in your customer base, and there was no probably record of that you probably had any acquisition of a new company, but the same company that actually had to metamorphose because of the provisions of the law. So it's good to have this on record that as at 2025, 2024, you have been given incentive provided for money to reduce their loss to 2021, but to put 2025 as a starting point to enable you improve and be more profitable.
So just for sake of clarity.
I didn't quite understand the question, if you can clarify.
Sorry, sir. We asked for the figure, and the figure cannot be either this or that. It is one figure. And we know, and you know, that the loss for EEDC right now is 21%. But if you like for us to show you a document, we'll show you a document. It is 21%. It's not 30%. It's not 25%. Thank you.
No, do you want us to respond to this? Chairman, sir. I could not understand the question that you are trying to ask. If you want to respond.
No, let me respond.
No, what I seek clarification is that a question which we need to respond, or is that a comment?
We asked a question that we wanted to give an answer. You left the question and started explaining other things that were not necessary. We asked you a question. What is the loss level that actually EEDC had in 2023-24 when we took over regulation in Enugu State, which was a loss level that the national regulator had provided for you and had provided you investment to make sure you attend that. You didn't answer that. And we're also trying to explain to you that actually those records, don't forget, we also have them. I only clarified on that as at that time, these are the numbers.
Yes.
So there's no argument or there's no question for you to answer or there's no clarification to give us because we already have the records.
Yes, we have all the records there, sir, to speak for themselves.
MD, sorry, so we go on. Please go on.
Let me just add on that question. You know, it's an important question. Pardon?
It's a matter of a number. That's a number.
Yes, but
so the number is A or B. And the number is one number. It is not a matter of explanation. And we know that you know that right now the loss for EEDC for the whole Southeast minus Enugu is 21%.
Yes.
It is in your monthly supplementary order. Anybody can Google it on the something and they will see it.
Correct, you see. Right. When you ask what is a loss, you see, the question is not very clear. There is a loss target, which NEC has put in the MITO. There is an actual loss, which the DISCO is now, at the level at which they are performing, having made some improvement. That gap is still there. So when you asked, it was not clear whether you're asking for the target or not. But what I want to say is that if there is a huge gap between the target and the actual loss, it means on paper you will demonstrate and say we've given them enough money. They will not earn that money. And that will now translate into a poor service. All we are saying is that there has to be some consideration of where is the utility and what is the target. It should be a reasonable target, which you can supervise as a regulator. It's your job.
MD, you are trying to complicate this matter.
Yes.
You have appealed, and we are going to look into the submissions you have made and things we have asked you to bring to us.
Okay.
But the important thing I want to understand is this. There are some basis and background we also need to establish. The Commission also has an interest to protect the customers. Part of those interests is a decision that the Commission will make, not you. And it's not a decision that definitely will agree with you because it has nothing really to do with the tariff per se because it's a regulatory decision. So we only ask you a question to establish some baselines. And those baselines is just what we wanted. The baseline we wanted actually is that what was EEDC's tariff as at the time we took over from you, loss level. You've given it to us. That is fine. 25%, 21% as at the time we were taking over. And which actually I mentioned to you that this 21, the national regulator, of which definitely I've also fortunately had worked there before, made allowances for you in your tariff to make investment which the customers will pay for through tariff. And after the customers have paid those monies at that rate, you are required to have reduced your loss level to that point. Then if it is not done, and you are now flagging as if it's a new company, which is a new name, quite fine, and then the same customers that have actually paid the money for that reduction, the decision to actually establish what the loss will be by our regulation is the regulator. If you have submissions to prove, because what actually we have here, which we have already tabulated and you have had the engagement with the consultant, is that you gave us numbers. In December, you gave us 37%. In March, you gave us 30%. Then in June, you stayed at 25%, which is what actually happened. Those numbers you are giving us, are just numbers that are changing. We also ask you during the discussion if you have done any studies that, or if you do anything that actually will verify, because we also have a duty to verify. We will make adjustments going forward. So I don't see it as an issue, but the bottom line is this. You had 21 which have been provided for you to make investments on. And then you are now asking us to give you something far higher than even what is there. We'll still be the one to determine what actually makes sense and what is reasonable for the customers. And that's why I was saying, if you have done any new studies, which definitely is different from these numbers we have here, we're open to have it, because we also need to review it to be able to determine what makes appropriate sense. So it's not for an argument, for discussion, please.
It's fine.
So we will continue from, you're about to take the next inflation. But please, you need to give us a pause for 5 minutes. A pause for 5 minutes is requested for whatever reason. Please, I don't need to disclose that, but give us 5 minutes. So very sorry. We can continue.
Okay, Dr. Mopoya, we'll now be looking at the inflation and foreign exchange, and which your request is that it ought to have been included. So that's your request. Can you explain to us how that will be included, given the existing formula for deriving revenue requirement?
Yes, thank you very much. We've been provided with a model to populate all our costs. Remember that these costs are in Naira. year by year. So a good model must have an inbuilt, adjustment for inflation going forward, based on some prudent estimates. If that is not included, those figures, the future figures, will actually be highly understated. That's what we're talking about.
Okay, so what figures now will be included, the foreign exchange, in the model? How will that be included?
The escalation by Forex. And let me say this, a power distribution business, most of the components are imported. So there is a Forex impact on both the CAPEX and the OPEX. Even fuel is tied to, the exchange rate. So a model must recognize those nuances and they must be built into the model.
Okay, so what we have, all right, I mean, this is a very important issue you're raising. But we have a situation, for example, in Nigeria where everything is imported. Therefore, the distribution business is based on importation, right? How do you explain what happens when, if today you hear that dollar has become 1.7 this morning, yesterday you were, for an example, buying a transformer for 20 million. Today the price goes to 1.7 and the seller of the transformer tells you, I'm now selling it 30 million because FX has increased. Because that's what happens to every product in Nigeria. In that case, wouldn't you now be capturing this 30 million as part of your operations cost? Because you will still not buy the transformer for 20 million. You're going to buy it for the 30 million now being sold because dollar has increased.
Are you disputing that a model should not have those adjustments by your question?
No, I'm not disputing. It's not in the model. It's never in any pricing model. What you would then have, for example, is a question of formulaic reviews, which will be based on maybe variance accounts. But in our context, is to be sure that we are not creating an inflationary cost and we're not doing what you may consider as double dipping. So it's about rationally looking at what we have and then being able to understand. That's why we need to understand from you how this escalation will be done. So I've worked as a lead rate economist in British Columbia Hydro. I've done the same in Hydro One Networks. And so when you read around within the literature and in practice, you then find that there are things that are considered as exogenous events that affect the distribution business. The question then is, how do you treat those things? Are they things within OPEX? Are they things within CAPEX? CAPEX, you cannot really negotiate. But if what we're talking about is the impact of Forex in what we're doing in an environment where everything you buy in Nigeria, nothing is made in Nigeria. So we have a situation which you will call efficient market hypothesis, where the news or the actual effect of the change in foreign exchange is applied instantaneously in the infrastructure you're buying. So the question then is, if it is applied instantaneously and you capture it in OPEX, how do you want this escalation to now be done?
I've understood you very well.
So
all we are saying is that the regulator should look at this and see to what extent they can build it in the model. It's not for me to.
No, I mean, I think it's for us. Yes. It's for us all to have a kind of understanding about what we're doing, so that we don't also create artificial increment in prices for customers, right? Because what the situation is OPEX is operations, maintenance, and admin. And that's where you're going to build in every infrastructure you're buying. So you have a situation where even you have a capex, the capex has both a capex figure and an operations figure. No, it does. Because if you have, for example, a transformer, right, and you have sustainment, that's OPEX. No, that, yes, in this, you have to capture them differently, but that aspect of sustainment of unless so here's sorry, where's the black one? Where did I come with one here? Okay, I brought it here. No one brought it. If you have your investment, or you can call it capex. Please, this is not bleeding well. This is not bleeding well. Okay. So for the whole investment you have, right, is in 3 categories. Do we agree? Correct. And these 3 categories, sustainment, expansion, operation. Now, for sustainment, there's still a capex element of sustainment. Yeah. And there's an OPEX element of sustainment. And that's the same for everyone. So that when you then have your OPEX, it will be this plus this plus this. Do we agree? Yes. I just wanted to understand sustainment. No, because this is for you to. Sustainment is your existing network. So you're sustaining it. Expansion, you can say expansion is new. So if you're building a new. No, operations is your admin. So within that too, you have some CapEx that goes into it. Do you understand? Okay, so what I'm showing, this is the way. Okay, so you consider sustainment and operations as the same. Okay, so, yeah, okay, I'm still saying, even if you merge this and this, if you need to granularize it, and if you need to be able to put it for easy review, then the line items should fall into these categories. So that if you're, for example, maybe in North America, maybe in Europe, and you're trying to make those submissions, you have to, put them this way. And that is also what is provided in the Act. So I'm just lifting this like that and saying, there's no problem. You can merge them, but even if you merge this and this, for each one, you have an OMA, and for each one, you have a CapEx element. That's just, yeah. No, the model is not structured like that. The model is structured as this, which are the building blocks, right? That's how the building block is. So in that building block, the CapEx is still the same. It's still this sustainment, expansion, and operation. Even if you don't call them that, it's still inside here. Depreciation is still inside here. The OM&A is still the same OM&A. So this is the building blocks. There's still allowable taxes. There's still the reasonable profit, which would then be this multiplied by this. So it's a standard all over the world. We agree? We're on the same sheet. In terms of new CapEx, so when you're being new capex, remember that you're setting a plan term of 5 years. And so what you're doing is to say there is a P0 and there is a P1. And the nature of your investment would be forward-looking. Are we agreeing? So that each investment will grow like this, year on year. And that's why Commissioner has said that if you're now having this and it's provided for you, then it means that as this is going that way, your loss is going this way. We agree? Yes. So the issue is there are fundamental engineering principles, economic principles, legal principles that inform the building blocks. Yes, and so we need to be sure that we're moving in this kind of direction so that that way the commission can be seen to protect you and also provide a just and fair rate for the consumers to pay. Are we happy?
That's the more reason we said
Then,
the target for efficiency should be slanting just the way you have.
Then,
Sorry, what will be slanting?
The target for efficiency should be slanting just the way you drawn it, because it is related to the investment for driving down losses.
Okay, so
that's the reason.
Yes, so it could be slanting, and it can be straight, right? Depending on, because what the commission is trying to do now is to ensure that we maintain that possibility for you to earn more. That's actually what they've done. So if we're taking this to be the cost that determines the price they've given to you, it's now saying that anything you do below this, you keep it until the next review.
You see, explaining like that, it sounds a bit attractive, but in practice, the initial years, you can actually create significant deficit in the operations, because you are selling point to say, look, in the future, if you recover, you get more money. What about sustainability in the year 1 and 2?
But remember, you're not just starting anew. Remember that
yes,
you still
but we know
have
the starting figure.
Yeah, no, you still have the fixed asset in the same place. I like what the MD said. He said that, yes, that Enugu in the southeast has the highest loss. And I thought that's interesting. Why? Because Enugu is your second highest load. Now, if your second highest load has the highest loss, but you have been receiving money to make the investment, then there's a bigger question there.
Yes,
but let's leave that.
Came about because of capping. I don't know. This is the third time I'm saying.
No. So that's fine.
That's
but what we're looking at is then, as we started, was how do we then say that we'll build in a Forex component when in this, immediately you're going out there to buy armored cable, is reflecting the foreign exchange immediately, instantaneously. That's a efficient market hypothesis. Now, if you then, after collecting the transformer, buying it now at the new price today of 30 million, then you come back and say to now make the foreign exchange a factor, it's double dipping. Okay, so that's why I asked, what do you want to be done?
What we are saying is this. Our CAPEX is programmed year 1, this level of CAPEX, year 2, this level of CAPEX, all the way to 5 years, right? Now, because it's in Naira, in the model, we have to ensure that the value is maintained, because the approval is being done now.
Yes,
we might find that next year or the year, we are unable to buy those transformers which we had planned for, because there was no adjustment in the model. That's all we are saying.
Okay, so remember in what the commission has given you, because when you say it's in Naira, what everybody does is to convert the dollar to the Naira value and put in the model, right? That's what everybody does. So it's not really that it's in Naira. It's the Naira equivalent of the dollar based on the exchange rate that is put there. Now, what you also have is that you were provided an over-recovery. And that over-recovery is not just for you to take it away, right? Because there's got to be a prudence check on that. Now, but it may well be, because we've had a series of meetings on this, in the commission, just trying to understand how this can be done. Because the other option is then to say, we then create OPEX variance accounts. So it doesn't affect you, so that in the event that you have, because remember, the revenue requirement is a forward-looking, is a budget, it's forward-looking. So the actual is always different from the forecast. Do we agree?
Yeah,
And actual is different from the forecast because of the energy you're transporting. That's your main business, is to transport energy. So the load forecast, right, will always be different. So if you have your load, it goes like that. That's the forecast, right? And you can then have your actual look something like this.
Or even more than.
Or you can have your actual this is not bleeding. Sorry. Okay, so let me do it with the black one. So you can have your actual look something like this. Either way, the utility has a challenge about sustainment. And so that is why ab initio, the commission provided over recovery. But raising the question around foreign exchange, around inflation, then calls into a creative way of doing this so that the consumers in Enugu, as the regulator wants, will actually be paying what is just and fair. So that if you then find this differential is what then causes your cost increment you're talking about. So maybe you also need to look at how do we then recover this? But it's not by saying that after you have purchased the things at the current rate and plugged into your OPEX, then you now have another inflator. Because even the question of inflation is still applied. The most recent report from the National Bureau of Statistics shows that when compared to last year, inflation, the rate of increase has decreased. It doesn't mean it's not increasing, but the rate at which it's increasing. And that is also captured instantaneously in the prices. So that the big question or the big elephant in the room here is, how do we then ensure that we are not double dipping? And how you can do that, you'll find in a lot of jurisdictions. Yes.
You need to implement minor reviews. There are no minor reviews in the order, regular minor reviews, like the way it's done at NEC. I think that's a fair one.
Okay, so if you're looking at, again, I don't call it minor reviews, I call it formulaic adjustments, right? So those adjustments ideally should be supported by variance accounts. Correct, right? So it's not now that, and so that is not going to be reflecting a foreign exchange imputation on it, or adjustment by foreign exchange. It means that you have an account. For example, you have an energy variance account, right? If we say we have an energy variance account, a T ledger, then what do? If you're now buying more, you have this situation because the variance is such that what they've approved for you is now less, right? What you will now do is you come here and put it. And it will be determined as to periodically when you will now come before the commission to depose the balances, subject to a portion of that being internalized by you. Just like insurance, will have the minimum you will bear. So if this is what you're looking to achieve, and that's why we thought that it's important we have this conversation so that we would, from our sketch, understand whether we're singing from the same hymn sheet. And if we are, then it may well be then for the commission to make a decision as to how it can create these variance accounts, which is what they are more interested or a lot more focused at doing, to ensure, as the chairman said, that you are sustainable in your business, but not to now say that there will be an escalator of a foreign exchange.
Yeah, the best practice is to have regular minor reviews.
Sorry?
the best practice in the industry is to have regular minor reviews which take care of those variances.
Yes, so, but it's not adjusting by foreign exchange in the sense we are saying. It's about then capturing your additional costs. Your incremental costs as a result of what you've been given is now what you want to capture, and this would be easily done and transparently where you have different, so you come to your operations, there'll be different variance accounts. And that would be something that is not the commission just imposing it. It's something that the commission will work with you to now determine so that it enables you to recover everything you spend.
Okay.
So, but I think, we have an accountant who can then see what I'm saying. I'm not an accountant, but in the work I've done, if we do that, it's double dipping. Okay.
Yeah, I think, Doctor, no, you can sit down. MD.
Just one announcement.
Okay, just a quick one. We know it's about lunchtime and people are hungry. So we have a light refreshment. So they will be shared to participants while the sessions are still ongoing. But please put off your phones. We don't want disturbance. We want this session to continue so that we can all leave here very soon. Thank you. So please, the people that are in charge of the light refreshment, please share them without disrupting the proceedings. Thank you.
Can somebody help me move the screen, the paper? So, MD, I want to find out something from you because these are some of the things you put in your petition that to us also was a bit surprising. The tariff methodology that is in effect in Enugu State. Did the commission go through a formal rulemaking process to put it in place? Just yes or no? Did the commission, EERC, go through the formal rulemaking processes to put the methodology, tariff methodology in place that is on our website? Did the commission go through the formal rulemaking process to do that? Yes or no?
Did the commissioner go through the rulemaking process?
Yes. Okay, what I mean, was there any consultation the commission did on the tariff model before it approved it? The tariff methodology and the tariff model before it was approved. Was there a consultation done by the commission?
Can you explain instead of asking questions? Just explain.
Uche, can you answer? Okay, Chidima, do you remember the time the commission published at the inception, the first workshop we had on the tariff and the methodology and the licensing? August. Was it done by the commission? Was it done by the commission? Done by the commission? Where was it done? Okay. Okay. Then after that process, did the commission also call the participants in that program to review what the commission finally arrived at that was going to be published on the website? It was done. Okay. They were open to the public. Fine. So why I'm bringing up this is this. Asking us to go and look into the model that you have been given opportunity to look at before it's approved doesn't sit very, very, very well. But if it is a submission that you have noted some things and you want it amended, you are still at liberty to write to the commission formally to do that. So it's just for you to understand that we need to follow a process to make things are done very, very well. And when you are involved in that process, and then you are picking holes in the process because of whatever reasons, it doesn't speak well, as if the process is not being followed.
Excuse me. I think the purpose of this hearing is for us to give submissions which can help you in decision making. The issue of making a submission through the rule process and so on has arisen because we noticed some obvious gaps. Any tariff modeling that is given, there must be some reviews because of the macroeconomic parameters that change. You don't have to throw it to us that you did consultation and that thing was missing. Why was it missing?
All right, so Doctor, please can go on.
Let me chip in something, Dr. Mupawaya. My sense and the Commission's sense is that we are working as partners, collaboratively, as a formidable team to resolve these issues. And I'm actually a bit concerned, not a bit, very, when I read the submissions and I have all the documents that were sent to me, just massive cartons like this. And as a third party, I could see that there were engagements, there were interactions. And when you look at the business rule, it provides two separate things, which is standard within the legal parlance. So you can actually, because what we're doing here and everything about electricity regulation is adapted from the judiciary. And that's why this is a quasi-tribunal. And that's why they are quasi-judges. And that's why you have to follow this process so that peradventure, as they'll say in Nigeria, you decide to go to court. The court of first instance is State High Court. And they are still going to be looking at the legality of this, the process the commission followed to admit evidence, and the justness and reasonableness of the decision. So that if you went to the court and said, commission approved 1,000 naira, the court wouldn't really care. Why? Because they don't have the skill to determine whether 1,000 naira is correct or not. And I'm sure we have some lawyers here. What the court would simply say, they apply the principle of due difference to the commission. But where their focus would be is the trial type process that was followed to admit the evidence. Now, if you then look into what has been done, you will see then that the business rule provides clearly for you to possibly have a written submission, which is what you guys did on over, I think, June, July. That's what you did. And then the decision was now communicated by that order. Now, the business rule also expects that you apply that order. You don't unilaterally say you will not apply it. Now, this process of this, what we are doing now, becomes what then happens if you then say you want an oral hearing. Because that's what you requested for in August, that you now want an oral hearing. And the provision here makes it that, yes, the commission can admit additional evidence. And all of this is happening so that the commission can cure one thing, the first issue that you were not fairly heard. Now, when it becomes that there are now documents that show that there were interactions and the process was followed ab initio, then it doesn't, in my opinion, tell well for any of us. So I think we should now strive to see, which is why we're saying Commission is more interested now in making sure that this no fear hearing doesn't arise. So that what you need, which you already have, hopefully you can submit them to the Commission later today or tomorrow so that it will be possible to have this concluded, right? So I will encourage us. We've all worked together in the industry. At least I'm not a new person in the industry. Everybody here has worked together. And with due respect, Dr. Mupawaya stood as one of first-class CEOs of a disco, right? So I'm not saying it behind him. We all know that. So we just want to be able to work together and get what will work for, as they say, Ndi Enugu. Are they having the right tariff? There's no need tweaking numbers because it's a business that will continue. Instead, what it is the real figures we will see, and then if there are areas where Enugu MAINPOWER needs support, then the onus is also between you and the commission to work together to derive that support. Okay? So thank you very much. Let's take the next issue, which is the energy allocation. And for the issues list, we have here that MAINPOWER had submitted 120 megawatts in December 2024. And on the 7th of March, submitted the same 120 megawatts. And on the 5th of June, submitted this 130 megawatts. The read or the interpretation is still like a conjecture on that graph I've drawn there, where you can see the growth in demand. Demand is growing. You have a lot of connections, so it may inform that. But in the petition, MAINPOWER is now saying that it's got to be 93 megawatts. One of the ways the system works is such that the lower the megawatts, the higher the price. And so the first thing when you look at this is to then think, okay, might it be that MAINPOWER, having seen the 160 megawatt, now decides in their petition, come 1st of September, figures that if I then ask for 93 megawatts, then I'm able to get a higher tariff if every other thing remains constant. If the commission doesn't change anything, then I reduce the megawatt and then I can get a higher tariff. So in commission's opinion, then that is not consistent with the growth in demand in Enugu, with the number of customers who, I haven't been to this Enugu, I think, since 2013. So, but driving down yesterday, I was really shocked at the number of at least hotels I noticed, at the large loads you have all over the place. And so I'm just thinking then, if we have to reduce the megawatt, but you're supposed to reduce losses and expand the network, then how do you expect that the regulator will now reverse to 93 megawatt? Thank you.
Thank you very much. When we are dealing with numbers, numbers don't lie. First, I must explain that we have to be very careful with the terminologies. Megawatt and megawatt hours, they mean different things. Megawatt hours is units of electricity. Megawatt is the demand of supply. You can have 120 megawatts, 200 megawatts, but you are only delivering 68 megawatt hours. I said numbers don't lie because we have numbers of how we have been performing. The entire last year we have how many megawatt hours, the units we received, as well as from January up to August. We have that number. It's total, it's submitted to the regulator as well. What we built into the improvement plan is that as we make more investment, we envisage to draw more units. In electricity, you can't just, increase supply without investment. You need to connect more customers who can get that power and so on. Or you increase the hours of supply. Both require investment. To increase hours of supply, I must reduce outages and so on. So we carefully planned it in such a way that every year we are building some infrastructure and increasing the consumption. But to put in a model, a step jump from 70 and below, 70 units and below, 70 million units and below to 120 million, 128 million. It's a big jump. And it's an artificial, it can't happen in a practical scenario because the increase is tied to the investment year by year. So, I said numbers don't lie. That number is there. It can be, we can be gotten from NISO. NISO, we have an interface, TCN and NISO. They can pick month by month how many units are getting into manpower. And it will be way below that 128. Thank you.
You then say where the optics is that you had 120, 120, 130. Then after the decision, you now, in your filing, now wants it to be 93. How would you comment on that? Because the only conjecture here is if every other thing is left the way it is, the only thing that can give you a higher tariff is if this load energy allocation is changed to 93. So how would that look? Because then it then looks like all you're trying to do is to see that you get a higher tariff, and particularly since you have then suggested that you're more than happy to have a 194.54 or a 206.80, even if it's not the 260.
Yes. The process of this tariff had a consultative process. In those 4 days when we discussed extensively on the correct number of energy we are importing before the order was issued. This is one of the 4 things that were ignored in the discussions. We were not going to reach this level where we're coming to public consultation if there was a fair way of looking at what is being submitted, prove the evidence, and pick that number. There was no agreement. So, please, just add on.
All right, thank you. Just like I said earlier, if we check the original submission on the 15th of May to EERC, you will find in their model, because we worked on their model and then resubmitted our data. If you go through that data, dated 15th of May, you will discover this year, 2025.
That is your June submission?
Yes. Our submission, the data was submitted of the model before your review. You find out that we said in our first year, we submitted to work and distribute 80.35 million units, which will give us about 110 megawatt hour per hour. If you check that, it's in the model, it's something was submitted. So, but what we discovered was when the tariff was published, that energy proposal was not used. What was used was a forecast we had done for the next year, which gives us that 1140 gigawatt hour or 94.96 million, which is absolutely beyond what we have in historic average. Our average is about 67 million units. So even when we took 80 million units, we took that on the basis that we've done 77 and then 77 and 80 are almost the same. So that was why we took that decision. So, but unfortunately, the tariff that was published, has a different energy allocation or energy proposal. Thank you.
A review of that. But let me also correct you, because you submitted 80.35 on the 15th of May. But on the 5th of June, you submitted 130 megawatts.
Would you like to see the document, please?
Sorry?
We'd like to see the document.
You would like to see the
Yes.
document. Okay, you'll be shown the document.
Thank you.
Because what's happened is you've had different submissions, and the submission of the 5th of June is 130 megawatt hour.
Because
right?
our last submission of the model
No, it's
is the energy
actually,
we're talking about.
don't worry.
Thank you.
After your 15th of May, you made another submission, and that was on the 5th of June. But it's not something we can just keep arguing about here. The most important thing is from the data distilled, just thought, this is something we need to clarify because the optics doesn't look good. If that is the direction, then it's fine, but we would then look at what it is.
Thank you. Just for us to clarify that we did not, it wasn't an afterthought because we saw the tariff. No. Because if we just take that energy we had proposed and put in the model exactly as it is, we'll not have 160, rather we'll have 198.58. That's just without altering any other thing. Thank you.
Thank you very much. Okay. Dr. Mopuaya, in your submission, you had given these two scenarios where you suggested that even if the 206 is not, that you were to give, you gave two scenarios. Scenario 1 is 206.80 and scenario 2 is 194.54. Is it possible to provide the commission with these scenarios?
Is it possible to provide?
To provide this so that one can see
the workings?
Yes, okay. And how it was iterated. If we can have that.
Yeah.
If we can have that by tomorrow, that would be great. Okay. In your scenario, you have a CBN loan repayment. CBN loan repayment. And we have also looked at the documents, what is not clear and what we would need to see. Because remember, the prudency issue comes into play. So what were these loans for? And where were these loans directed? So it's one thing to say that there were loans taken, for example, for meters. Who are the people who got these meters? Who are the suppliers of the meters? I hope you understand. The issue is the commission, because this is still part of what will be your CAPEX. So the commission would be able to say, this will now be taken in as part of your regulatory asset base, right? And provision will be made for the interest to continue to be paid. But it cannot be made just on paper. There's a 0.34. The commission needs to audit those loans and see exactly what infrastructure are they tied to. So it's something that would be helpful if maybe we use the segregation of investment there, or even if you're merging sustainment with operations, but to identify the CAPEXs that these loans were used for. And also to provide copies of the loan agreements so it's easy for the commission to actually understand that this loan was for this purpose and there's evidence it was used for that purpose.
Yes, we'll provide that information, but just remember that the loans were procured by EEDC. So what we've made a provision is the delineation of the obligation for those loans.
Okay.
The documents are available.
Yes, but the loans were provided to EEDC.
Yes.
The consumers in Enugu Disco will be repaying the proportion of the loan that was used on their network.
Correct.
Yes. So the consumers in EEDC, in Enugu Disco will not be paying for a loan that was used elsewhere. The MD has graciously explained that other states besides Enugu have lower losses. Now, if the loans were applied in those states, then it can be collected from Enugu.
Yeah.
Are we in agreement?
The capping, please remember capping of estimated when you talk about it.
Yes, so the issue is, it's not, the commission is not adverse to allocating this. because it's first appeared in your statement here where you have it, right? Now, so that there's no question around no fair hearing again, this is now an element that's appeared here. So for this to be accepted and implemented or included, then it's important that these documentations are provided. Whether it's CAPME, whether it's what's it called, distribution loans that went through TCN, but each disco had to sign for it. It's not a problem. The only thing is, can we identify the exact infrastructure used? I mean, the exact infrastructure it was used to procure, so that Ndi Enugu will pay for what is on their network.
Fine.
So, given that these are facilities, EEDC also already has in its files or in its system, it's something that you can also be able to provide at least by tomorrow, so that it will be easy for the Commission to audit those loans and accept the ones that will be integrated in this recovery.
Okay.
Thank you so very much. Thank you, MAINPOWER, EEDC. Thank you, the interveners. Thank you, the general public. I see some of my bosses are here. We greet them. I think we are about concluding this proceeding, but just to make sure that the rules of natural justice are observed and seen to have been observed. So we would ask MAINPOWER to please give us your final address of not more than 5 minutes. Summarize, not more than 5 minutes. Not more than, 5 minutes, sir. Please don't ask for extension. You have the time starts to count now. What are your final comments, as the case may be?
Okay, thank you, commissioners, thank you, interveners, and our customers at large for this opportunity. It has been quite engaging. From our side, we also value this process because it also serves as a communication platform. There are a lot of issues which we've had to explain. This business is highly technical and very sensitive. The issue of a tariff is like a double-edged knife, which is sharp on both sides. It can either hurt customers or it can hurt the utility. But what is required is to find that middle point where a good service can be delivered while sustaining the business. And also, there's a fair price so that customers are in business, the utility is on business. I think, in all fairness, if all the issues are taken on board, we are confident that we will reach some good landing. There is one point which I wanted to just emphasize on. There was a mutual understanding with the regulator, to have some input from an independent consultant. Our prayer is that although we have submitted the document, please look at it, see the merit of it. It can be useful for both the utility and the customers, because at the end of the day, the business must be sustained. I must retaliate that we have a very, very ambitious program to transform completely electricity business, something we've done before somewhere. It is doable. There was a time when one utility where, the customers, they don't even know what a transformer looks like. Because the stores had enough stocks, enough poles, enough meters, and so on, to the extent that the customers must take it for granted that when they have a fault, it will be resolved. That's where we want to get there. These resources we need, they should be allocated. We use them prudently. The utility is next door to us, the regulator. They will check step by step what we are doing. If supported, in the next 2-3 years, the electricity business will be at another level. I thank everybody. I think this is the way to go. We are looking forward to a good outcome because a lot of effort has gone into this. We'll provide all the required information so that the regulators have sufficient material to work with. Thank you very much.
Thank you, sir. Thank you very much. So we will give maximum of 2 minutes to each intervener. We will start with ESEA. Man is not here. ESEA, 2 minutes. If you go beyond the 2 minutes, we will take the microphone from you. Oga, 2 minutes, and the time starts to run now.
2 minutes, too small.
I know it's too small, but that is closing. 2 minutes. Please, General Counsel, make sure that 2 minutes are not exceeded by any person.
I want to make a very humble application.
It's refused in advance. So 2 minutes.
Good evening, the commissioners, and I just want to stand on existing protocols. My commissioner, I recognize the MD of...
please, no protocol. You are making a closing remark.
Okay.
So please.
I want to state here that His Excellency, the Executive Governor of Enugu State, Dr. Barrister Petandubi Simba.
I'm sorry, but you're losing it. The 2 minutes. Please go into the heart of the presentation. There are 5 other interveners. Please, I'm not...
okay.
Please, just go into the heart of it and 2 minutes.
Okay. I think the commissioner feels stampeded and ambushed, but all the same, I'll try to be brief in what I'm going to say. I want to thank God for this opportunity to be in this program, and it's actually a learning curve for a lot of people that are here. But suffice it to say that I will quickly go to my closing remark here, and then get done with it. In my closing remark, I just observed that the Minister of Power, Chifa Adebayo Adelabu, had in the month of February 2025 observed that there was a great inequality and unfairness in the tariff order of NEC that gave 209 to Band A. He didn't see it quite, and he said that as a matter of fact, that the federal government is committed to making a review of the current tariff order as it were given by NEC because of the so-called perceived unfairness and of the order as it went there. So what it means is that when I look at what EERC has done so far, I simply want to note that it's actually a four-sided movement that actually agrees with what the federal government wants to do now, which is to reverse the order of 209. And I could recall that immediately after the order was given, some members of MAINPOWER and some team visited me in my office, as the managing director of Enugu State Electrification Agency. And they also made a plea to me that I should assist them to ensure that the government pays its bill regularly because the tariff given to them gives them marginal allowance for bills by government, which happens to be the biggest customer of Manpower. If it's not paid, that they may not break even, which to my mind also is an acceptance of the fairness and justice of that, the order of 160. But I was surprised.
One more minute.
Okay, but I was surprised that on the 31st of July, having had a meeting with them on the 31st of July by 12 a.m. precisely, Manpower shut down the power supply to band B to E without any implementation of the order. So when I heard the MD say that, yes, they observed the order for 17 days, and yet from the submission, from what we know, it's just about 3 days. But if the order of 160 is observed, because of the so-called technical hitches, they said, that the system of entire South is going to collapse. And then I wanted to ask a question. When you observed it for 3 days or for 17 days, did the system actually collapse? And who was the witnesses to the collapse of the system? So of course, the truth must be said. The tariff order given by EERC, to me and to the host of the public seems very fair. And one of the indicators of the fairness, just a second, one of the indicators of the fairness is the fact that after the issuing the tariff order, that Manpower did not shut down the Band A customers. So why was it that the one that was reduced was not shut down? The power supply to Band A were not shut down, but then that of Band B to E that was not touched, that was freezed, was shut down. It leaves a very big question mark, And then in summary also, I've heard the MD say, give us 209 or 194 that will have more money to invest. I had the privilege of being the head of operations of Enugu Electricity Distribution Company for some time. And then from there, I joined the government of Enugu State. And I can tell you for free that transformers were not bought. Materials were not bought. Customers were forced to. Customers were forced to.
I think
buy.
We have to be fair to all. Please. Thank you very much. Thank you very much. Thank you very much. I know you have a lot more to say, but we would have appreciated it if you had given us a written submission well ahead so that we can put it to them so that they will see and speak to it. Thank you very much. All right, so in this order, can we see Sika? Sika, 2 minutes. If you don't have anything to say, you don't have to. Come on.
Hello. Okay. In summary, what we just want to say is very simple. And it's to the DISCO Manpower. Please, the provision of meters is very important because metering helps to reduce losses. So when there's a lot of meters in the states which you are functioning in, then these losses will be really minimized. Then investing in infrastructure is very important. There's not been investment since even the EEDC came into play, and then Manpower, and we see these responsibilities of buying these infrastructures done and being, mustered by the communities and the consumers, as a matter of fact. So if this provide poles, these cables and transformers, which is supposed to be your responsibility, then the feeders should be improved upon, because a lot of all these loads and they're having a lot of losses downgraded and collapse in a lot of bands, which is making the power supplies to be inefficient. I think there should be a lot of improvement on the feeders. So these infrastructures, all this will help to remove these losses which the DISCO is incurring. Thank you.
Thank you very much. Nekai, you have the floor. You have 2 minutes. Please use it well.
Thank you so much. I would like to go straight to what I have to say. The point is, EDC, what as MAINPOWER, what I'm encouraging them to do is to get very rigorous in their operation. Because anywhere you look, you don't really need to look very deep to see a lot of inefficiency. It has not been long ago, I was talking with business manager in Nsukka. I mentioned CCDR. He doesn't know what he was telling me, what do I mean by CCDR? Then at the customer complaint unit, you don't see people who respond to you. So if you go and check the cap, they don't look at it at all. So the other time, we saw when they were looking at Lifeline customers, they did a lot of errors there. They published a lot of names that is not traceable. So you don't, anywhere you just try to follow the regulation to look, you will see inefficiency in the system. It is everywhere. In my community, for instance, now, we bought 500 kVA transformer. Up till now, it has been installed. They are going back and forth to see what they are going to do to energize the transformer. And they are asking them to pay money again for it to be energized. This Oga that is here now, they bought 300 kVA transformer at Hilltop in Nsukka. After buying that 300 kVA transformer,
1 minute more.
Everything was done by them. So when you look at their system, what they should be looking inward when you talk about reducing cost. They should be looking inwards, because you see a whole lot of people who are not trained in the system. If you get 5 or 10 people, train them very well, they can do a job of 100 people. So this is 21st century, and people should not be running things with analog everywhere. So that's what we are saying. So we are going to be looking at it. The customers are getting wiser.
Thank you.
The customers are getting wiser, and we'll be taking them up from everywhere.
Thank you.
Thank you.
Very much. Thank you. No, thank you. Yeah, I am happy that you say we'll take them up, not by physically boxing somebody here. So that is fine. So I think we have the Enugu State multi-door courthouses represented here. I don't know whether you have anything to say. If you have, you can use 2 minutes.
Thank you. Well, as an observer, the Enugu State multi-door courthouse has followed what has been happening right from the initial proceedings where the introductions were made, and I'm actually very happy with how things panned out today. I don't think any of the parties, whether EEDC or the public, will say afterwards, after now, that there wasn't fair hearing. Everyone has been accorded that opportunity of presenting his or her cases, and I would like to thank the Commission, because I know this is a very novel area. Enugu State is leading the trend in this direction. And I want to thank all the participants, especially the doctor who led the discussions. I thank you so much. Thank you.
Thank you so very much. Yes, so we are rounding up now. I want to make one announcement, then my panel members will say something. The documents that any party is to give to us, the only party that has until Monday to send us any document is SICA. Between today, tomorrow, Friday, and Monday, whatever you have, if you don't come within this time, we won't look at it. Now, for MAINPOWER, whatever you need to give us between today and tomorrow, Because we're believing that anything you are giving to us are things that are already existing. If it is something that you need to create, then it is late. But whatever you need to give to us, we must receive it between today and tomorrow. If we don't, we won't look at it. I think it's just fair for us to be upfront about that. Please, Dr. Akunne, I don't know what you have to say. Yes, sir. MD EEDC. Okay.
Could I get 5?
Sorry, very sorry, very sorry. You have a right to use your, in fact, I'll give you 3 minutes. Speak.
First of all, I am here as an intervener and as a parent company of the MAINPOWER. So I'm taking this opportunity. Instead of 2 minutes, I seek 5 minutes. I think what has happened today is unprecedented. And we are really, really happy that what has happened today is something that is going to be beneficial, not only for MAINPOWER as a company, not only for EDC as a company, but for the larger people, public interests of the Enugu state as a whole. And why I'm saying this? EDC has been the parent company, as we all know, sirs. And the fact that we have already swung into action even before this Electricity Act came, even before the Regulatory Commission in Enugu was formed. We, immediately after the new government that was formed, we actually were already planning a 3-year strategic plan for Enugu state as a coal city, for Enugu as a state. And that plan was very much aligned to the governor's vision and the vision of the state government as a whole, to be able to do 24/7 power supply in the next 3 years, and also ensure that affordable electricity is made available to every citizen in the state of Enugu. And that was the commitment that we had worked with, and therefore are truly aligned to this commitment that we have made. And therefore, this aspect also dovetails into the MAINPOWER strategic plan, which it has already presented to the EERC. So coming to the specifics, however, the objective and purpose with which we participated in this, I think has been achieved. I only wish that we talked a lot of things about procedures, business rules, so on and so forth. Retrospectively, now having gone through this process, I would only like to comment that had this process happened before issuance of the order of tariff, maybe we would have seen a different tariff order, which would be acceptable to both the MAINPOWER, EEDC, the NESI as an industry, and would have been acceptable to everyone, had this hearing kind of thing has happened then, before the issuance of the order. So that's one point which I want to make. But on specifics, I would only like to say here that whatever MAINPOWER presented in the petition, we are fully supportive of the need to look at the factual numbers and deriving those numbers that need to be used in the model very, very accurately, because each of these numbers has a sensitivity with the end tariff. And due respect must be given to the factual data that we need to sniff through over the last years or last year or this year. Whatever that needs to be done, we need to correct those assumptions that have been taken in the tariff. Particularly, I am referring to the 5 elements that we discussed today. One is the RAB. Second, and most important, is the energy offtake. Because we can't be planning something which is not possible. If we look at the entire last year's record, the highest energy offtake has been about 70 million units. Now,
MD, you are giving evidence, so
no,
just summarize.
Yes.
That's what we asked.
So,
that.
the second point that
we
I
have
want to say,
minute, 1 minute left.
Yes, the second point which I wanted to highlight is the aspect of energy offtake, which needs to be closer to reality. That is what needs to be built in the model for computation of tariff. On the third aspect, I would also agree that we need to look at the OPEX very, very critically, because OPEX is also dependent on the macroeconomic situations and the indices of the entire country. I can't be running an OPEX budget of last year with this year's fuel prices. That actually distorts the entire OPEX, and therefore the aspect of inflation, etc., that we discussed also need to be suitably factored. And one last point that I would like to say here is that the EERC issued a capping order and regulation. Now that single capping order, since the month it was issued, I don't think MAINPOWER, decided and said that no, we are not going to follow this order. But factual matter is that on implementation of that capping order, MAINPOWER's billing efficiency has dropped by more than 10% points. And that is the fact of the matter.
MD,
once billing efficiency drops, the
we've
efficiency level
generous
drops.
with time.
We
need to stop.
This is the last point that I'm saying.
No, we need to stop.
So
I gave you five minutes. In fact, 6 minutes.
Apart from the 5 points that I said, which we need to review and address and correct them, I'm saying that this capping regulation order also needs to be suitably reviewed and put in place in the future. We are together with the EERC and also want to work closely with the government.
Thank you very much.
Yes, thank you, sir. Thank you.
Thank you. Thank you. Thank you. So, I'm not prolonging this engagement, but just to let everybody know that the issue of estimated billing that they're talking about, they've just submitted to us a proposal that they want for going forward, and we're reviewing it, but it took 11 months for them to send us that proposal. We first asked for that proposal November 2024. Say, you don't like what you have. Give us what you want. And it took 11 months. It was in this September that they sent to us their proposal, and we're looking at it. So please, we will address all of that. But we will never accept that estimation should be a permanent feature of our electricity supply industry. It must be a stopgap, and so we cannot build a house where everything is about estimated billing. I think I just needed to make that clarification. And whatever they are talking about, we did not invent a cap. We used the national cap that they were operating. And if you look at the difference between that national cap and the fixed cap that they had for about 4 months, sometimes the difference was about 1 unit. So please, let's also be mindful of that. These are issues of numbers. They are not like things that you can't easily verify. Sir, sorry, sir. Sorry, sir.
There's one important point.
Sorry, sir. No.
Sir.
No, sir. MD, no, sir. You have made your submission. Please, sir. I'm not being disrespectful, but please, let's go by some rules. Thank you, sir.
Thank you very much, Chairman. In a closing remark, I just want EEDC, especially MAINPOWER, to understand one thing, and that is that EERC wants them to succeed. Our chairman here has said it over 100 times, we want you to succeed. We want you to succeed, and that is what we are working towards. We want you to succeed because we know that if you succeed, that Enugu State succeeds. So we are bound to do whatever we need to do within our rules to make sure you succeed. And I'm here to state today that you will succeed. On the part of the consumers and the groups, in ensuring that MAINPOWER succeeds, we are also committed to ensuring that your rights and privileges are protected to the letter. We are not going to shake on that. It's a balance, and that is why we are here to maintain this balance, to make sure that all the parties get a fair deal. So thank you everyone for coming, and I think we have all been part of this history which has just been made. We thank our consultants, we thank the pressmen, our staff, and the security men and other people. So on behalf of the chairman and the panel members and our staff, we thank EEDC and MAINPOWER for coming. We're all partners in progress, and we keep working towards that. We also thank the customer groups. Thank you too for coming. We are all going to get what we want from the system. And the consultant, thank you so much for your technical input. All the people that came to listen, and the audience, thank you. The pressmen, thank you. The online participants, we are grateful. If we had some hitches, we apologize, and we make them better next time. Thank you so much, and bye-bye, everyone.